Yes.
Next one.
May I please go next? I beg to mention item number 19, my love. Earlier, Peace Vaikya was engaged in this matter. Yesterday, I received the file. I need some time, my love, to prepare the case.
Okay. You're taking consent of the other side.
My love, I will inform.
No, you will inform. No, this is very dangerous. Why should somebody keep on waiting for your information? No.
19.
No. You make the prayer when the matter is called. You get the list in 2 days in advance. Why you should not have the courtesy of informing your brother and sister lawyers who are in the matter? You should have basic courtesy. Why should I tell you what courtesy you have to extend with your own fraternity? But am I the authority to tell you? You should know it on yourself. Would you like it? Would sit in the entire day and then come to know that in the morning somebody took an adjournment? Would you appreciate that? No, not without prior consent. No. Yes. Bail is a matter. Anybody is present? You are there for the bail. You have seen the record.
Malad, yes, record Malad, in the Malad, say Malad 164 of the victim was there, and he took the name. Basically, they kidnapped the person and took him to Bangladesh, Malad.
Yes. I remember
And
that.
again take back. Subsequently, he was recovered.
Yes.
So the order rejecting, it was reflected that the person was,
In the process of recovery, the only point which
yes,
I think Mr. Ahmed will urge is that the recovery was of his own. He was not recovered. That means without police effort, he was recovered.
but they took him to Bangladesh, again came back. That point was recorded in the order rejecting page 37. That,
But he was arrested 23/6,
yes, that is, yes.
about 300 days. No, 292 days.
292 days.
292 days.
Regarding the delay, yes, considering the length of detention,
has charge sheet been submitted? Yes.
Yes, the charge is submitted. The case is at appearance stage.
Still in
Next
appearance
date is
stage.
2/5/2023.
Where is that statement?
Page 46, your lordship, 45, your lordship.
last sheet dated 31/7/22.
This is the last order. Page 45.
Page 45.
Yes. 46, your lordship will find the next date.
Okay. Well, Mr. A. Azad, then counsel for the counsel for the petitioner, Mr. A. Ahmed for the petitioner, and Mr. K.K. Parashar, and ABP appearing for the respondent. Petitioners, two petitioners. Next, perhaps. The petitioners who are in judicial custody since 23/6/2022 in connection with so and so have paid for regular bail under section 439 CRPC. The learned AVP has perused the records of B82287 of 2022, which contains the scanned copy of the case records received from the Court of Learned's Chief Judicial Magistrate Karimganj. And he has opposed the prayer for bail on the ground that the accused, the petitioner accused, had kidnapped the son of the informant, and he was taken and confined in Bangladesh And ransom of rupees 2 lakh was demanded for safe release of the son of the informant. So it is submitted that the victim boy has been recovered. So it is submitted that the previous bail application of the petitioner was rejected by order dated 29/9/2022, passed in BA 2287 of 2022. And it is submitted that the the petitioners had managed to travel to Bangladesh with the kidnapped victim. And therefore, if the petitioners are granted bail, or there would be no chance that they would cooperate with the trial and cooperate with the trial. So accordingly, the prayer for bail is opposed by the non-APP. Next paragraph. The learned counsel for the petitioner has referred to Annexure Roman 9 of this bail application, which is an order dated, which is a copy of order dated 13/3/2023, passed in GR 3371 of 2020. And it is submitted that the case is still in the appearance stage. And the next date of trial is fixed on 2/5/2023 for appearance. Accordingly, it is submitted that the case is still at committal stage. And there is no chance of a early beginning of trial. Next paragraph. The court finds that the learned APP has made a point that as the petitioners had kidnapped the victim and he was taken to Bangladesh, the petitioners have easy access to Bangladesh through some forest area in the border. And it was the same reason for which the bail was refused, the order dated 29/9/2022. Next paragraph. However, it is seen that more than 6 months has lapsed and the trial is still at the committal stage. And according to the court is of the considered opinion that in this case, bail ought to be granted with certain stringent conditions. Full stop. accordingly, considering the fact that the case is still at committal stage, and the next date of trial is fixed on 2/5. Next case proceedings, the next date of proceedings is fixed on 2/5/2023 for appearance of the absconding accused. The court is inclined to grant bail to the petitioners, namely so and so, on their furnishing a bail bond of rupees 1.5 lakh each, with 2 solvent sureties of like amount to the satisfaction of the Honorable Chief Judicial Magistrate. Current bench. First off, in this case, both the bailers should offer his or her immovable property as security for grant of bail. Next paragraph. Bail is granted on the following conditions. One, that this order of bail shall be in operation till the completion of the stage of committal, and when the case is committed to the appropriate court for trial, the petitioners would apply for a fresh bail from the learned trial court. Number 2, that the petitioners, along with the bail bond, shall submit an undertaking that they would attend the court on each and every date of hearing. And in the event, for some compelling reasons, they are unable to appear before the learned trial court, they would ensure that they are duly represented by their lawyer, who is well briefed to continue with the trial. And in the undertaking, the petitioner shall also undertake that they would not dispute their own identity or the identity of the witnesses who are examined in their absence. Next, in the event the committal court finds that the petitioner is absent on call on any particular date, said the court would be at liberty to enforce to cancel this bail and to issue fresh non-bailable warrant of arrest to secure the presence of the petitioners on trial, and simultaneously the court would also be at liberty to proceed against the bailers. The other conditions are there. Application disposed of, the registration attach the records of DA 228 of 2022, 2287 of 2022.
Obliged.
My lord, if it is not inconvenient to the court, my lord, another item was there, item
Yes.
929 last.
Yes, you can take it up. Counsel is present.
Sorry, madam. I am informed regarding extension. But let the item reach, my lord.
Okay. What is this IFO? What is this IFO?
I is for, my lord, I has been filed for a modification of the, my lord, bail condition. He is from, my lord, Kasar.
45 days. What is your
Yes,
instructions?
My lord, I have the report from the, my lord, my lord. He is hearing, my lord,
On each date.
yes, within 15 days, my lord. 14/2/13, 16/3, 24/3, he has appeared, my lord.
Oh, no, it's okay. We don't need it. Once you have it. So we extend
My lord,
48
yes.
days. Okay.
29.
But this, as the learned counsel for the petitioner, as well as Mr. K.K. Parashar, learned APP for the state. Next paragraph. This interlocutory application has been filed by the petitioner accused for modification of condition numbers within bracket C and within bracket D of the order dated 25/1/2023 passed in BA 11 of 2023. Next, the Learned Counsel for the applicant submits that the applicant is a resident of which place?
Kachar district, your lordship,
Oh.
Sonapur part 2, Gangapur,
Sonapur, part 2,
in brackets, Gangapur.
within bracket Gangapur, which is located, which is under the jurisdiction of Borkhola, Burkhola, yes, in the district of Kachar. First of all, it is submitted that the petitioner is about 65 years of age and does not have a place of residence or big accommodation at Guwahati. And therefore, the applicant is finding it difficult to travel to Guwahati within a span of every 15 days and to bear the cost of travel and accommodation. Hence, the Learned Counsel for the petitioner applicant raised that the condition be modified to make his appearance before the IO every 45 days. Next paragraph. Pursuant to order dated 6/4/2023, the Learned APP has obtained instructions from the IO. And as per the written instructions from the IO, dated
Dated, my lord, date not given.
not given, okay, written IO, the applicant has appeared before him
11.
on
My lord, 14/2/23, 1/3/23, 16/3/23, and 24/3/23.
okay,
I have received it yesterday. I have received.
okay. Next paragraph. Having noted that the petitioner has not, the applicant has not violated the conditions imposed upon him by the order dated 25/1/2023 in BA 11 of 2023, upon considering the difficulties which the applicant is facing to travel from Kachar district to Guwahati every 15 days, the court is inclined to accept the prayer made by the applicant and modify condition number C and D to the following effect. The modified condition C and D would now be as follows. You see, that's right. The petitioner shall physically appear before the investigating officer once every 45 days. And condition D, that it would be open to the IO to question the petitioner during his appearance. Just in that CU, right? Till his personal appearance is dispensed with or charge sheet is submitted, whichever is earlier. Necessary to interrogate him. Stop. According to this, interrogative application stands allowed to the extent as indicated above. Next, this order shall be read together with order dated 25/1/2023, passed in BA 11 of 2023.
Not just one clarification. He's not gone to Kachar yet, so he has been here only, Your Lordship, since his release.
Oh, sir. That he's been traveling. You say that because of the condition, he has not been able to leave Guwahati for his hometown. Just manage it.
Most obliged. Your Lordship.
Item number 1 for admission.
This may the kindly possible for the time being, in London register is in the leg code number 1, my lord.
We will take it after some time because there is some query arose. And therefore, I've asked the learned Advocate General to make a submission. Question has arisen in this case.
I had a small submission. I have prepared a written argument, my lord. I may be allowed to file this case.
After that, you just let Mr. Saikia Advocate General make his address.
Yes.
Item number 2.
The matter will be talked about for time being, Lordship. 4 also, Lordship.
3. Item number 3.
Here, Mr. Mazumdar was to tell us, he was required to obtain instructions.
My lord, after some time, my lord, he is in leg, my lord, in code number 1.
Okay.
So he will. come back.
5.
What is password for the time being?
4.
5.
Yes, Mr. Ahmed.
Maybe your lordship. Lordship 5, 6, 7. 7, 8. 4 cases. No, similar matter. The cause of action and relief sought for are the same, my lord. So last 6 to 7 years, no reply from the respondent side, my lord. So it is
It's okay.
difficult-
You can proceed with the submission.
Lordship. So, my lord, non-reply and evasive
No.
reply amounts to admission, my lord. If they.
That will depend if you can successfully demonstrate your case.
Lordship.
Since I belong to that civil school, even an ex parte decree, you'll have to earn on your own merit.
So, my lord,
So at least you'll have to show me.
Yes, yes. Lordship, I kindly pointed out, my lord,
Is your case covered by that screening committee report?
No, my lord, my case is covered by the judgment already passed by this honorable court, my lord. That we are in a created post, my lord, supernumerary post, my lord. So for supernumerary post is concerned, my lord, taking the aid of the honorable appeals court, my lord, honorable, this high court has already passed 2 judgments, my lord. Covered by that. Similar
No,
case,
but-
my lord, yesterday
but-
also, I made the same submission, my lord. Then they take time to file reply on that, my lord.
No, because supernumerary posts, now the Supreme Court has changed the standard. It says that the courts can't order creation of supernumerary posts.
That is, my lord, not, last 6 years, no reply, no review, attend.
No,
final
that is okay.
reply.
That is why I'm started to hear
Attend
you.
final reply, my lord.
But the issue now is that creation of supernumerary posts has been demanded by the Supreme Court. It has categorically said no.
Actually, we are not a supernumerary post, my lord. They have created, madam. They have owned their created, madam, supernumerary post, madam. We are a regular, madam. Only they made the
No, but
allegation
I found
and
somewhere
failed to
that
made
the,
out, madam.
no, but somewhere I found that you are also projecting that the salaries were stopped at a particular point of time.
Yes, madam. Madam, lordship will find, madam, period of service has been regularized. Giving Provident Fund, opening the service book, confidential report and all, everything, madam, not the post, madam. These are the elements of the regular post, madam. So, madam, humble sorry for your lordship, madam, let them file the reply, madam, so that we can respond to that,
No,
madam.
because you
Otherwise,
see-
each and every occasion, madam, they made submission, only made allegation, my
No,
lord.
Mr.
Take the
Ahmed,
matter out, my lord.
see, that is why I'm proceeding to hear the matter. I can't go to the house of each and every officer,
Lordship,
give them an invitation card
no, Lordship can
to
pass
attend
direction, my lord.
to attend the court and to file the response. If they don't appear, you start your argument.
Lordship can, Lordship may issue direction, my lord, not, no need to go.
No, you have to satisfy me. Direction is something which will have to satisfy the court.
Lordship, page 50, the appointment letter, my lord, initial, my lord.
50.
Page 50, 50. Lordship.
Yes, type and read, sir.
Is a, in column, paragraph 1, my lord. See, because successful training will be given the regular time scale of pay as per prescribed ROP 1990 plus other allowances as per. This is the allegation, first event, my lord, I mean the appointment later. Same, my lord. All are the same, my lord. So it is a promise given by the government, my lord. After completion of training, my lord, they will be given the regular salary. Then, my lord, page 93, lordship. He has completed the 1-year training service, my lord, as per Brigade. Issued by the District Institute of Education and Training. What was found that?
Just a moment.
Yes.
Page.
It is page 93, lordship. That is annexer 2, page 93. My lord, completion of training, my lord. Issued by District Institute of Education and Training, Sibsagar.
Just a moment.
Then lordship, page number 112. Page 112, lordship, regular scale of pay, my lord. Page 112, lordship, 112.
Do you have the advertisement person to which this posts were advertised? The selection took place. Do you have a copy of that advertisement? Because I did not find it here.
Lordship. My lord, may not be in this case, but in other cases, my lord.
Okay.
Lordship, page 150. Page 150, 150.
150, yes.
That's. Assistant teacher of primary school, maybe HSLC pass or equivalent.
No, but this is not for stipendiary teachers. Page 150, this is advertisement not for stipendiary teachers.
And this is not a estimated teacher, so we applied as a assistant teacher, they appointed as estimated teacher, my lord. And that time, my lord, I think, my lord, lordship will be aware, my lord. No treasury salon was required, my lord, in those days, mean 91, my lord. So here we fulfill the all criteria, my lord, that's why you are called for interview and all, my lord, then selected, my lord.
No, but
Yeah.
150, you see, page 152 relates to lecturer in Cotton College. It's nothing to do with stipendiary teacher.
There are some other pages, my lord, blurred, my lord, next page, my lord. Totally blurred, my lord, this is, I am finding difficult, lordship is not able to read out, my lord. They are the custodian of the all records, my lord, let them file, my lord. Just 90, it is a paper of 9, published in 90, my lord. Almost 30 years back, 30 years back, my lord. I have annexed here, there was copy, my lord, everything has been blurred, my lord. Page 152, lordship has seen, I think. But copy is with my learned brother, my lord, they are the main custodian of all records, my lord. Somehow I collected these papers, my lord. Everything is blurred here, my lord. So, my lord, next page 112, lordship.
Yes, Mr. Karani, can you explain this page 152?
152 mother seems to be an advertisement, my lord, of 1991. Whether this is pertains to this selection process or not, my lord, this is not discernible from this advertisement, my lord.
No, since you don't reply, you will admit it that you have admitted this.
My lord, in
For
fact,
6 years, if you don't reply,
that I understand, my lord, but they have filed an affidavit, though I don't have the brief, my lord. I have checked with the board brief, my lord. I have filed an additional affidavit in reply filed by the petitioner. They have filed it against the additional affidavit filed by the respondent number 1, my lord.
yes.
In that case, my lord, there may be some affidavit filed by the department, my lord.
It's an affidavit in opposition filed by respondent number 16.
Yeah, well, the petitioners filed an additional affidavit in reply on 29/10/2018 against an additional affidavit filed with the respondent number 1. The respondent number 1 is the Commissioner and Secretary to the Government of Assam Education Elementary Department.
That is not there in record.
But I have, in a second file, my lord, I have got that copy, my lord. That is why there's a little bit confusion. This is, I have seen from the second copy, my lord. 4618, the number is also same, my lord. 4618.
Hold on. No, this affidavit is there, but but your affidavit is not there.
That is why, my lord, I'm in a little bit confusion, my lord. So
Okay.
may I pray for some time, my lord, so that whether we have filed or not, that I can confirm, or in addition, if required, my lord, because
You
they
have to
are
give it time.
anyway, they are subject to a screening process, my lord. That instruction I have, my lord. So I will bring it on record, my lord.
Okay. Because Mr. Ahmed, we'll have to adjourn it. The affidavit is not on record.
Well, let them reply, madam. They have made allegation and failed to made out, madam, last 7 years. Failed to made out. Only the attacking madam illegal and irregular, madam.
No, whatever be,
particulars.
but that affidavit is not on record. It appears that it has been filed, that's why you gave a reply. Uh, But this affidavit, I don't think it would be on record because otherwise it had been tagged.
Yes, my lord.
Also that really represented. Mr. Anjay Khatuniya Lonel, standing counsel for the Elementary Education Department. Has submitted that he has gone through the court file and has observed that the petitioner had filed an additional affidavit in reply against the additional affidavit filed by the respondent number 1, i.e. the Commissioner and Secretary to the Government of Assam, Elementary Education Department, which was filed on 29th. The said affidavit in reply was filed on 29/10/2018. That's where it is observed that as an office note dated 18/7/2018, it states that inverted commas, Education Department, DEP, full stop, has not filed affidavit. Full stop, inverted comma closed. Full stop. Accordingly, the Learned Standing Counsel for the Elementary Education Department shall ascertain as to whether the affidavit which was served, affidavit on behalf of respondent number 1, which was served on the Learned Counsel for the petitioner, was actually filed before the registry or not. Court is inclined to grant 2 weeks time to the Elementary Education Department to verify their records. Matter stands adjourned today. It is made clear that on the next date of listing, the matter would be would not be adjourned.
Item 6, 7, 8. Also similar.
Same, it will go.
Yes, my lord.
And they may be lots in my humble prayer, if you lots, they may be
List.
also reply the already made by.
List on A8/5/2023. Fixing a date for hearing.
Yes, yes.
8/5.
Obligations.
Obliged, lordship.
Number 9.
Yes. The question is not appearing.
Last submission also, one petitioner was not present. That is related to pension. So we take up the matter after the. The petitioner council is not there.
But this is already a covered matter.
That read April 160.
In this case, I question the marriage. Because the certificate, marriage certificate has been obtained after the death of the husband, my lord.
Oh, where is that? It's page 22.
Yes, my lord.
Is the legal head certificate? Where is the marriage certificate?
Marriage certificate, Must find page 14.
Page 14.
My lord. It was, my lord, issued on 1/11/2014.
No, that doesn't make a difference because it's your Qazi who is saying that the marriage was registered under serial number 9 dated 4/1/1991.
But the Kavin number is not present.
It may not be there. You see, I was married long back in 91. I may not have the what you call documents of my marriage, except for a few photographs. I may not have it
Take up the matter in presence of the council for the petition.
because this is otherwise covered matter. Why should for pension we should pension payment orders? Why should we adjourn it? Because in a moment in marriage, this court has accepted that both the wives they'll be entitled to sharing of that pension. Because you see, about 10 years, 9 years has gone by. Husband has died. Why should we delay the adjudication? Maybe because the lawyer of the petitioner is not there.
Immediately after vacation, my lord, so that my lord, I will consider my case, my lord, in the case.
Because I find that your basic defense is that under the conduct rules, you are saying that only one marriage is permissible. That is the only ground, but that has been dealt with by this court. And what is the citation of the case you are referring to, Khurshid Ahmed? Because I'm not getting that citation. In your affidavit in opposition, you are referring to Khurshid Ahmed Khan. You have the citation with you?
Khurshid Ahmed Khan, my lord, 2015 8 SCC 439.
2000.
15 8 SCC 439.
Oh, there's a spelling mistake. That's why I'm not getting it. Okay. But again, this citation would not apply because the state government did not initiate any proceeding against the person.
Yes. My lord, paragraph 4 of my affidavit in opposition, my lord. Losime Kali Peru, they have not controverted this paragraph.
But you know, Mr. Saikia, with the statement you have made in paragraph 4, the onus is on you to show that. Because there's a documentary evidence on record showing that there was a marriage of 91 which was registered with the Qazi, and then a certificate was produced in 2014. Now this under the Assam Muslim Marriage Registration Act, the Qazi has the power to make entries in the register. Correct. And he has the authority to give a certificate copy of the marriage certificate. Correct.
But this is not a certificate copy. The certificate they have annexed is not a certificate copy.
Oh. Okay. Local ex Muslim MOS alien. Yes, Okay. There is no representation from the petitioner. First of all, the petitioner defaulted in appearance when the matter was previously listed on 8/12/2020. Next paragraph. Mr. I.S. Sekel and counsel for the respondent, number 6. Had submitted that the respondent number 6 is questioning the admissibility of marriage certificate within bracket annexure 1 on the ground that the marriage was solemnized on 4/1/1991 and the certificate is of 1/11/2014 comma, which was procured after the death of the late husband of respondent number 6, who had died on 5/9/2014. Full stop. It is also submitted that the admissibility of the marriage certificate within bracket Annexure 1 has also been questioned on account of the fact that this was not that the said certificate is not a certified copy of the extract of the marriage register. It is also submitted that although Mohammedan is may marry for more than one time, but under the Assam Civil Services within bracket conduct bracket close rules, 1965, such marriage ought to be entered after obtaining due permission from the authorities, which was not done in the case. Next, neither has it made as the petitioner is absent on call. The matter stands adjourned today. It is made clear that if the petitioner remains absent on call on the next date of listing, adverse orders would follow. List of transferring due vacation. Actually, you are also there. Mr. Jeep. People on government advocate appearing for respondent number 5, and Mr. A. Fukan for respondent 1, 2, and 3. And you are
For respondent number 4.
D. Rabha for respondent number 4. Okay. Mr. Segia, there is
Item number 1.
yes.
I have gone through it, Lordship. There is an inadvertent mistake in the rules itself. It should have been 8(4),
Yes.
not 8(c).
Yes.
So I leave this to this honorable court to read it down, Lordship. Otherwise, there is no difference. But the only thing is that even in the advertisement of the 8(c) is mentioned, and also in the rules,
It can be read down.
it can be read down, Lordship.
Okay. Okay, thank you.
Yep.
I'll just record your appearance. I'll
Lordship.
pass the orders in chambers.
Lordship, highly obliged.
Thank you.
Lordship,
No, this was a gray area where
Lordship.
I wanted to.
No way we can be connected. It was actually the mistake at the legislative level.
No, I understand, but without hearing you, I thought I should not
No,
take a.
absolute Lordship. We have no difficulty. Otherwise, we will have to do it.
Okay.
Now it has come to our notice.
Okay.
If Lordship is reading it down, then it is easier for us also. Highly obliged, Lordship.
And I would also thank you for a different reason altogether. I was informed that because I am a one-track person, having spoken to you, I also spoke to the DGP when I met. And I am told that with your effort, they are now taking up the matter for what you call the appropriate training to the IOs.
Yes, sir.
Because last time I told you the APP is here, he was here. Huge quantity of drugs were recovered from Rajdhani Express. In Rajdhani, we have sleeper coaches 3-tier AC, which are B11. It is B,
B.
but in the scissor list and in the what you call the and all other places where he is writing his notes, he has written the coach number as S11. And then the IO also writes that the person was sleeping on the berth, and we recovered the consignment from below. So you see that conscious possession itself was lost. And it hurts me because of the fact that when the state government is doing so much and the police is doing so much and the amount of drugs which are being seized in the country, in this state,
State.
is very, very alarming.
That's- What kind of business was going on?
Yes, what kind of, what is
Ah.
this enormity of the scale? Was not as a judge, but as a citizen, we have a duty towards
Absolutely.
the
The
system.
families who are having this kind of persons addicted to drugs, they actually know the trauma.
Yes, yes, you're right. That's why I'm thanking you sitting here.
And
But
we'll do lots of
I-
whatever is
I-
possible.
I thought I should communicate to you. I don't know whether I'm doing it right or wrong, but
I'll
thought-
convey to the right persons, Lordship, because the police officers, they are very dedicated. And
yes,
whatever,
yes.
and they are very
Two or
ready
three,
to,
2 or 3 senior officers I met. I am really
Yes.
amazed. They are
very good team now.
they are
in the
very
police,
good team.
Lordship, very good team. Very professional, and they are ready to learn. If they are not dogmatic. That is the best part.
no, that is good. I thank you for your effort. It has given result.
Obliged.
Yes, you can hand it over.
Item number 10,
I'll record your presence and I'll pass orders in the chambers. Maybe today I have some meeting to attend. I think by tomorrow I'll release it. You want to add anything orally? You want to say anything orally? Anything further you have to say?
I have nothing to say.
Okay, you have anything more to say?
My senior is already concluded to service.
I just wanted because of that error in the provision, section 8C is not there. So I had to give the learned advocate general.
May it please your lordship.
10.
Your lordship, this matter, in all probability, it has become infectious. But I need to actually get written instructions from my client to withdraw the writ petition. So may I pray the matter will be listed immediately after the vacations? And by that time, I'll get the written consent.
Okay. Also, the duly represented, Mr. D. Boral, counsel for the petitioner, submits that he has to take instructions as to whether the subject matter of the writ petition is alive or not. Full stop. According to matters adjourned today, they start to ensuing bifurcation
After 26, after 26.
after 26th. Released on 28/4. then. Your call, university.
Yes, Lord.
Oh,
No, item number 11 and 10. 10.
okay.
11,
Make the zero check. This case, my lord. Regarding
Yes.
appointment of headmistress, my lord.
Yes.
So. I have misplaced the file, my lord. In between, I found it, again, it is misplaced. Probably, my lord, as I have come to know from the other side, she's been appointed as headmistress, my lord, in pursuance of the order of this honorable. So I unable to contact
Because the counsel for the private respondent, he has made a submission that the matter has
Yes,
become
my lord,
infectious.
yes. And somebody, other client, my lord, has informed me, my lord, that she's been regularly working as regular headmistress.
Okay.
But
So,
I could not contact personally, my lord, because the phone number is in the file. My lord.
okay, so you want the matter to be adjourned?
As your lordship, please, it may be closed or it may be fixed after the vacation.
Okay,
If
no,
I want
because
to
we,
confirm
because for the purpose of closing, I like to record your statement. If you don't want that to be recorded, then we'll adjourn it.
First week of May, let me
Okay.
advance contact my lord, because.
Okay. Also, as a duly represented,
the phone number.
uh, Mrs. N. Saikia, and counsel for the petitioner, pays for some more time to obtain instructions as to whether the matter has become infructuous.
Alright.
List in the first week of May 2023.
All right. Okay.
Well,
Yes, Mr. Das.
In this petition, Lordship, we have basically challenged the screening committee report. In the Nagaon district, wherein Lordship, they have stated that only one candidate is found to be working till date. We are earlier filed, 2-3 petition Lordship. And our
Yes.
services were regularized long back in the year. And no
Lordship,
affidavit has been filed, Lordship, till date. No affidavit has come from the respondents till date. Lordship.
I think we'll be-
Katania is going to appear, my lord, in this matter. Can this taken, matter be taken after some time?
Okay.
Please appear.
After some time.
Two similar petitions, your Lordship was pleased to direct the respondents to file their affidavit. That two matters came on 15/3/2023.
Just see if they have instructions after some time.
Obliged.
Item number 14.
Yes, Mr. Mazumdar was to give us some instructions. Mr. Sharma, you have the instructions in the matter, item 13,
Item
13.
I think that in my lord, it is showing as elementary matter, my lord, elementary education.
No, secondary education also. No, I'm sorry.
for
I'm sorry.
secondary.
No, I'm wrong. I'm wrong. I'm- This is item 13.
14.
I mean, our Mujumdar will come here, my lord.
Okay.
Fourteen. 14.
Yes.
Lordship, Mr. R. Sinha used to appear in this matter. Today he's got some personal difficulty. Could the matter be taken up after the vacations?
It's a similar one. Yesterday, ours in IPA.
Yes, you have filed an affidavit.
Yes, madam. I am fine. Affidavit.
Okay. On the, all sides are duly represented on the prayer made by land council for the petitioner. List after answering due vacation. Okay.
But this matter has been listed along with another 881718 that was listed yesterday. Similar similar issue, my lord.
Along with WBC.
8817 of 2018.
Okay.
15,
Much older.
Wait, video. Last mail of 4/10/2021. And the secondary department got paid for which time she was time to file affidavit. Until today, my lord, they did not file any affidavit.
May I please your lordship? Lordship, in this matter, affidavit is not required, my lord. Here, my lord, well settled law is there, my lord.
They appear.
Jahangir Alam and Abdul Bari. So here appointment was made by the managing committee, my lord. Managing committee and without following any procedure of law, my lord, they were appointed and he was continuously doing his job, my lord. In this respect, my lord, Abdul Bari was in our high
It's
court.
okay. It's okay. If you're not filing an affidavit, let Mr. Bora argue,
Yes, ma'am.
then we'll hear you. He's not filing an affidavit. He's
Yes,
ready
ma'am.
for the hearing.
It is a covered case, my lord.
Fine. Today itself, my lord.
You want to do it today or some other day?
As your lordship, today, and this is the gate for employee, my lord. My lord, he was appointed before provincialization, my lord. And his post was not, my lord, considered for provincialization.
Yes.
And my lord, he is working regularly. And thereafter, my lord, this post, his school was upgraded, but 2 posts are vacant. And as per annexer, my lord, if honorable court permit me, page 28, my lord.
Yes.
The 2 grade 4 posts was vacant in Harmony Higher Secondary School, page 12, my lord. Page 28, annexer 12, my lord. If honorable court permit me.
Yeah, yes.
My lord. Before that, page annexer 11, page 27, my lord. May I read, my lord?
Yes.
Submission of application for grade 4 post submitted by Sri Rosseswar Sunwal. With reference to the subject cited above, I have the honor to submit the following few lines for favorable kind attention and special consideration. That, sir, we the Harmony High Secondary School severely facing hardship for last 3 years to maintain official grade 4 workload due to shortage of office staff. Reports are already filed to the concerned office that our one grade 4 employee, Sri Pradeep Sutia, has been missing since 5/11/2006. With about 700 student enrollment, the 8th class school runs with 1 permanent grade 4 employees. Applicant Rosseswar Sunwal has been serving as grade 4 employee in the school vice managing committee letter dated 1/1/1992. And such from 1992, my lord, I am working. My lord, 2 grade 4 posts are still vacant. They did not fill up, my lord. I have 2 pair before lordships. 1 pair is, my lord, for if honorable court regulation cannot, my lord. So I have alternative pair is there. If the post is fill up, my lord, I may be considered because of that law from 2000. Kindly see my pair, my lord, page 9, my lord. Simple pair before lordship. That the writ order direction like nature should not be issued directly respondent authority to initiate a process to fill up the 2 existing vacant post grade 4 employee of Harmony Higher Secondary School, Lakhimpur, and further direct the respondent to consider the experience of the petitioner in a regular selection process and alternative direct respondent to regularize the service of the petitioner grade 4 employee. I am pair only, my lord, limited pair, my lord. Before lordship, 2 vacant posts are now still vacant in the school. The schools are also required for.
Yes, Mr. Sharma, let him continue till you fill up the post. He'll be permitted to, what you call, apply, by, moving the appropriate authorities for continuation of overage.
Yes, madam.
So, my lord, now there is a new rule come into effect, and moreover, my lord, there is a selection procedure also there, my lord.
He'll comply with that, but if it's overage, you will have to condone it.
Yes,
The authorities will condone, since 92 means, how many years? 29 years.
yes.
Yes, sir. But Mr. N. Bora, learned counsel for the petitioner, as well as Mr. U. Sharma, learned standing counsel for the secondary education department, appearing for respondent numbers 1, 2, and 3, and Mr. R. K. Talukdar, Mr. R. Sharma, learned counsel for respondent number 4.
My lord, I want to place my lord to judgment. My lord. Yes.
Next, the case of the petitioner, is that he was appointed as grade 4 employee of Harmoti HAR-MOTI Higher Secondary School, Lakhimpur, by the then managing committee of the school on 1/1/1992, and it is projected that for last 31 years, the petitioner has been serving in the said school without any break. First off, by referring to the vacancy position, in the said school, it is submitted that 2 grade 4 posts in the said school is lying vacant for quite a long time. First off, however, long time is how many years?
From my lord, 2009,
Six.
my lord.
2009. So it is submitted that as per his instructions, since the year 2009, no effort has been made by the respondents to make regular appointment in the said post. That said to grade 4 posts. First off, the learned counsel for the petitioner has fairly submitted that in view of the settled law on the issue of regularization of an employee, it is submitted that the alternative prayer of the petitioner is that the petitioner may be given an opportunity to participate in the selection process. Until then, his service should not be disturbed. Next paragraph. The learned standing counsel for the secondary education department has submitted that it's a settled law that employees who were appointed by the school managing committees without there being any prior approval or sanction from the appropriate authority, such an employee no vested right for being, for his service being regularized. And in this regard, he has placed the reliance on the case of Abdul Bari within bracket MD versus State of Assam and others, 1999 within bracket 3 bracket close GLT 31. Followed by order dated 17/6/2003, passed by the division bench of this court, common order, dated so passed by the division bench of this court in WA. So not common order. Order dated 76/2003, passed by the division bench of this court in WA 252 of 2003. Which is also followed in the case of Jahangir, JAHANGIR, Alam and others versus State of Assam and the others, 2003 within bracket 3, bracket close GLT 544. Next paragraph. The court takes notice of the fair submission made by the learned counsel for the petitioner, that the petitioner is ready and willing to offer his candidature as and when the selection process is initiated. Full stop. Accordingly, the learned counsel for the petitioner, who is abreast with the law in this regard, has not pressed his prayer for a direction to the respondent authorities for regularization. Hence, the cases cited at the bar by the learned standing counsel for the secondary education department is not required to be dealt with. Next paragraph. In this case, the respondent authorities have not denied that there exists 2 vacant posts of grade 4 in Harmati Higher Secondary School from Lakhimpur. Post of the specific stand of the specific submission of the learned counsel for the petitioner is that since the year 2009, the authorities have not made any effort to fill up the set 2 grade 4 posts. The learned counsel for respondent number 4 has also submitted that in the absence of regular appointment to the grade 4 posts, it is difficult for the college administration to properly manage the affairs of the school. Correct?
Higher secondary school now.
Higher secondary school. How many students are there?
Case 21.
How much?
Page 21, my lord. In higher secondary section, my lord, 65. In 21 numbers of teaching staff and non-teaching staff.
No. How many students are there?
Students, my lord, 275 in higher secondary, my lord.
It is submitted that in the higher secondary level, the school has 265 students,
75, my lord.
275 students.
That was in under 92 letter, my lord. That was letter dated, my lord. 275 students. In higher secondary.
As on
As on, my lord, 6th August now 1992.
6th August.
6/8/1992.
65.
And stop. Next paragraph. In accordingly, the courts of the constitution that as the petitioner has rendered 31 years of service,
Vacancy status of 1994. 93.
and therefore,
So, sanction for-
in the event the vacancies are advertised for filling of the grade 4 posts in Harmati Higher Secondary School, it would be appropriate to provide that in the event the petitioner seeks to apply for such for appointment to such post, the petitioner would be at liberty to move the appropriate authority in the secondary education department. Who is the appropriate authority for condoning age?
Director, secondary.
Director.
Yes.
I, the director of secondary education Assam, and also, and is provided that on such application being made for condonation of age, the same, the petitioner is permitted to annex a certified copy of this order so as to enable the competent authority to consider the claim of the petitioner.
My
And
lord, regarding the condonation of S, director may forward, my lord. It is the personnel department who will take the decision.
personal department.
Yes, my lord.
No, as per new notification is director is there. In every department individual right. Now new notification. As per my knowledge.
Directors are there in the department, but my lord, as per the office memorandum 1951, my lord, we have to send it to the personal department along with all the
Okay.
documents. They recommend the
Okay, just
Condonation of
we just ended there. In the previous line, you just stopped for those. The Learned Standing Council for the Secondary Education Department has submitted that the application for condonation of age may be made before the Director of Secondary Education Assam. And as per the Office Memorandum of 1951, the Director of Secondary Education Assam would have to forward the same to the Personnel Department for an appropriate order for condonation of age. Accordingly, it is provided that in the event the petitioner makes an application for condonation of his age before the Office of the Director, Secondary Education Assam, the said authority shall do the needful to forward the application of the petitioner to the competent authority. It is the court hopes and trusts that the application of the petitioner for if any filed for condonation of age shall be processed by the authorities in the Office of Director of Secondary Education Assam, as well as in the Office of the Personal of the concerned personal department of the Government of Assam within the within that what do you call within the time of closure of the
yes,
application.
yes.
What is the right
Yes.
within the prescribed time for closure of the applications? And the authorities shall not dispose of the shall not reject the candidature of the petitioner merely because the application is not accompanied with a order of condonation of age, which would be communicated by the competent authorities to the Secondary Education Department. Correct?
Yes.
Next paragraph. According to this, representations goes with the observations as indicated above. Observations and liberty as indicated above.
Right.
The next paragraph, till regular appointment is made to such post, the respondent authorities shall not disturb the service of the petitioner.
Must.
You have noted this, Sati, please.
What should
Just one. I'll take a break and come back.
Lordship, in item number 14.
Just renew that when I come back. Yes.
I am appointed by the governing body of SS College of Hailakandi on dated 3/1/17. On the
Just a moment.
Lordship, in this case, Lordship,
Yes.
Lordship, in this case, Lordship, we have received instruction, Lordship, in long date, Lordship. In 6/6/2019, although it was received, Lordship, but due to some Lordship misplacement, we are not able to file our affidavit, Lordship.
The affidavit is there by Director Higher Education.
Affidavit is there.
Yes, January 2023. You already have the
Lordship, kindly second copy, Lordship, we can. Second.
If you'll come to that para 4, last part.
Lordships, I have seen it, but Lordship, proper text are not placed as per instruction. Instruction says that, Lordship, the interview was held on 22/4/2015, Lordship, and proposal was sent by the college authority 4/8/2016, Lordship, after more than 15 months. So, Lord, in the meantime, Lordship, it was elapsed, Lordship. So, these reasons, Lordship, government has again Director has again written to the letter to the director of government lordship for administrative approval lordship. Because
But now you see,
lordship,
in this para 4,
lordship,
last part,
lordship, I have seen
there,
lordship.
there you have stated that you have already given administrative approval. So if the approval is given, why should you delay the matter? They only have to fill it up.
Lordship, it says that administrative approval is not given lordship. But the government of Assam Higher Education did not accord necessary approval till now, for which another letter so and so was issued lordship. For according necessary administrative approval for filling up the post lordship.
So who is going to give this?
Lordship, this is for filling up the post lordship. Filling up, because lordship,
No, for the purpose of filling up,
lordship,
the petitioner can apply in that.
petitioner can apply it. Because lordship, early advertisement lordship, what's the actual fact is that lordship, after more than 16 months, the recommendation was given to the authority lordship.
Okay.
That's why lordship, that period was lapsed lordship. That is the main issue lordship here. Otherwise, regarding that part lordship, administrative approval is given lordship, then petitioner can apply and lordship, he can participate the selection process lordship. That part we have no problem lordship.
My lord, I have already selected, I have faced the selection process.
No, but you have to now again, Mr. Das, you'll have to again now subject yourself to the process.
And already I'm working in that for last 6 years on the consolidated payment.
But that would not help it. As the proposal had already lapsed. If you can overcome by some, by showing some case laws or otherwise, because if the proposal has lapsed, then the fresh approval has already been given.
It's not my mistake, my lord, that is the mistake of the administration. That is not my fault, should I suffer already once I have, for last 6 years I am working. Again, I have to go for the same process, then I may not be selected, whereas I am working for the consolidated for last 6 years. That is admitted by the principal.
But can we undo that? So last, can we undo that?
Even lordship, principal was so caused by the directorate also lordship. Why they have sent the proposal lately lordship?
Can we undo it, Mr. Das?
Yes, my lord.
How?
Since I am class 4 employee only, I am not having that much knowledge. So what to do that authorities do the mistakes of the authority, that some wrong in the authority, why I should suffer, my lord? I'm working for last 6 years for consolidated pay. Again, if I am made to face that reasons interview, then I may be not successful in that. Already. January 23. Recently,
Who's appealing for the college? You are appealing to college? Mr. Lal, but it can't be helped. Once the authorities, the college authorities don't send it.
My lord, is after 4 years, this authority, this approving authority, today only they have come to the court. Whereas this is filed before 4 years. This case was filed before 4 years. Today only they have come with them.
No, they have filed their affidavit, they have taken that
They have
stand.
not filed this, they have filed the affidavit. This respondent number 2 have filed the affidavit.
Yes,
Respondent 2 and 3 have filed it.
yes.
Admitting the fact, whatever I have mentioned in that, this is medicine.
No, that is not addition. You see, they are categorically saying that the appointment was not made within the time prescribed and therefore it has lapsed. So once it is lapsed, whoever has made the mistake, but the mistake has happened.
For the mistake of administration, why should I suffer? Poor fellow, why should suffer? Well, this is for a delay of the.
No, Mr. Das, for that I don't have any answer. The only answer perhaps which I can give will hurt you. The only answer which I can give is that you have a right to claim compensation. But once the appointment has lapsed, you show me a legal way. You see, there must be a legal way to do it. Unless you can satisfy.
Madam will be fixed after vacation, my lords.
Okay, you must show me a legal way.
That's what, sir.
Not that the court has power and the court can do it,
It's,
but there must be a legal way out. Because once the post is lapsed, and the point which Mr. Gogoi is making has not been, what you call, the college has not come with clean hands. They have not stated about those things, which he is pointing it out. There was a delay and the college authorities said that they have sent it in 2015. But 2015, there is no communication to that effect. Even in their affidavit, they have not seen it, they have not placed that. That's why I was reading it. In their affidavit, they have not stated that in 2015 it was communicated. Okay. Also, is it duly represented on the pyramid, Mr. B. Dawson and Council for the petitioner. This matter after ensuing due vacation.
Congratulations.
Just a moment. Uh, Next one. In the meanwhile, the higher education department is at liberty to file additional activity in open seats. If. Shortlist.
12, item number 12.
Worship this petitioners worship, they are working since 1992, 1994. And their services were regularized long back. Worship may kindly see the regulation order at page. Page 17 to 26, worship. Page 17 to 26 also. 17 is the type copy, worksheet 18 is the original one also. In pursuance of the Assam's letter number so and so, the following working teachers are hereby regularized to the sanction post by government letter number so and so with effect from 24/4/1998. There he will get his pay and other allowance as admissible under rules as stated above. Page 19. Page 20. Page 17 to 26 also, may kindly see it.
Yes.
Then thereafter the other advertisement we applied. Now we have been level as regularly appointed teachers. Our salaries were not paid. Then we are subject to a screening procedure, but we are not giving any, we are not hard losses. And losses, the interim order losses is at page 64. In Nagaon district, they have stated that there is only one candidate who is found to be working.
But what has come out in other petitions is that advertisements were issued in every in several newspapers
Yes,
requiring that.
Yes, we have applied, we have also enclosed our salons also.
Where is that?
Lots of, we will find that page 48 to 52 also. Advertisement is page 47, 48 from 48, page 48 onwards, 7 column. Application fees for upper primary school under Director of Elementary Education. All the petitions are applied.
Oh, what is the post?
Also assistant teacher also. I mean for
Assistant teacher. Because page 50 makes an interesting reading.
page 50.
Yes. Particulars.
Lots of Abul Qasim and 5 hours. 12 and 13 cents.
So, Mr. Mazumdar, it will be subjected to fresh screening. They'll be subjected to fresh screening if they are.
If Lordship will have the impugned order, which is at page 66, the relevant portion of page 60, what their grievance. Page 66.
Yes.
Decision. Having regard to the above, it is clear that the appointment of all these 8470 teachers, as well as 752 and 14 similar teachers of Dhemaji and Lakhimpur district, fall under 4 district categories. Appointments during the ban period, appointments by school managing committee, appointments against knowledge post, no record of valid appointment. That being the position, the Director of Elementary Education is directed to issue individual so-called notices to all the 8470 candidates and 766, including 752 Tamil teachers, Dhemaji and Lakhimpur district, indicating therein the reason as to why their appointments are deemed to be illegal or irregular, and as to why they should not be removed from service for being so appointed in violation of the existing rules. The decision of the department was that we will give them a show cause notice, giving them the opportunity, because we were not satisfied with what had come up with the screening committee. Even before these show cause notices have been issued, petitioners are before this honorable court. Now, my lord, if this honorable court deems it fit, if the matter is closed, I had a discussion with the counsel for the petitioner. If the matter is closed and in case the department gives him a show cause notice, either he replies to it, and if the department does not give him a show cause notice at all, he is not being disturbed as of today. And in the meanwhile, in case he is not being paid his salary, he can take up that case with a representation saying that you have not given me a show cause.
No, you see, why I'm disturbed is that there was an order of 21/12/2018.
My lord,
In this order, the operative part is, in the circumstances on the next date fixed, the learned standing committee for the elementary education department shall provide the information as to whether the initial appointment of the petitioners are acceptable appointment in order to enable the court to pass an interim order requiring the petitioners to be retained in service.
my lord, they have not been disturbed. I have asked it. They have not been disturbed. Although there is no stay order, we have not disturbed them. We have not even given them a show cause till now because of the pendency of the case. If this case is disposed of, we have decided to give him a show cause notice prior to terminating his services or whatever the circumstances be. In case we give him a show cause notice and the show cause notice is not lawful or is not in accordance with law, he can always come back. In case we start a proceeding being not satisfied with his reply, even then he can come back. But at this stage, my lord,
You see, Mr. Mazumdar, the submission of you appears to be attractive, but you see, there's a catch in it.
my lord,
This proposal to issue show cause was in 2018.
yes,
Now 5 years have gone by.
yes.
You have not done it. Which each passing day, they reach they become overage for one reason or the other. So after extending their service from time to time, without issuing a show cause, now to subject them to a fresh screening.
I'm not saying that now that we will subject it, because Lordship will see in 2018, this was the order. We have placed orders before this honorable court in other cases, where in 2021, many people have been regularized and many people have been regularized as tutors and teachers. In fact, my lord, this 878470, many out of them have been regularized because there was another conscious decision which was placed before the cabinet. I'm not going into all those in this petition because the grievance is only restricted to the extent that they want to give me a show cause. I may be included in one of the persons who is going to get a show cause. That was his apprehension. He approached this court. As of today, my lord, no show cause has been given to you. Lordship may give a time bound free. In my humble submission,
No, but
Lordship.
you see, what has to be done by you has to be done by you.
Yes,
Why
but-
should the court give you a direction that you do it in?
No,
a
what
particular
I
fashion?
was saying is that in case the department desires to give him a show cause notice, Lordship may bind us by saying that it will be done within a month or will not be done thereafter. It will save his time, it will save our time. If we decide to give it in a month,
But this
things
this
are
would become a handle for you to issue a show cause, which you have not done. You see, why should I waken you up?
here,
If you're comfortably sleeping.
because this screening committee report, if I place before this honorable court, screening committee report is going to show that he is not there in the list of persons who that screening committee had taken to be, who could have been regularized by us. Thereafter, my lord, whether he attended classes or not, whether he deposited a treasury challan with us or not, will all be questions of fact. He shows a treasury challan. He does not show that it was deposited to us or we have encashed. He will never be able to show. Our records of Nagaon, if we now to trace it back to the year 2015 or 17, is going to create havoc. It will
No.
only prolong the litigation. That is why I was, in my humble submission, my lord, instead of prolonging it, since it is, even this show cause notice does not carry his name. We have not said that he will have to get a show cause notice that he is going to be terminated. If it is a period of 1 month, if his name was there, who are required to be given a show cause notice, we'll give it to him. He'll have a proper opportunity to defend himself by bringing in all these documents.
But Mr. Mazumdar, you see, please come to page 50. It's a random page I have taken up.
Yes, ma'am.
There is a seal of the bank.
The treasury officer, the treasury challan has been
No,
deposited.
the seal of the bank is there.
Yes,
Scroll number is written and that seal of the bank is there.
yes.
So prima facie, he has produced the challan, he has deposited it. If you see,
No, what happens is this money has been deposited to the treasury is not an issue. That the money, that we fill up the treasury challan at the treasury office, my lord, the treasury officer gives us a challan, we go to the bank, deposit the money, bring it back to the treasury office, he seals it. Now this challan has to be deposited with the department, along with his application that I want to be reviewed. Whether he deposited it or not, because it is under a head.
Also in the
Once
particular
we get-
process, it has been written, Director of Elementary Education, Assam, the second column was.
No, that is in favor of.
What Mr.
Whether
Mazumdar
he
is saying,
submitted an application.
what Mr. Mazumdar is saying, that you deposited the challan, that is okay. But whether you have applied along with the copy of the challan, that is a question.
They have applied.
There is a question that will not be perhaps better before this honorable court. My humble assumption, I would not. So therefore, in case the department has all the details of the persons who were illegal and who have not been recommended for being accommodated as teachers or tutors. If he falls into one of them, it is his right to have a so-called notice before we take action against him. The
No,
moment this order came that issue, so-called notice to those persons
No, you see,
is before the court.
even for that prima facie, you'll have to controvert what he's saying. In this writ petition since 2018 for 5 years, you've not controverted that. You've not taken a stand till now before this court that the department disputes their appointment.
Lordship would like to have it after the vacation when I'll have
Also,
the
in case
application for the question.
what my learned friend is submitting. If we are put to so cause, what's it then we can be again put to a screening procedure also, re-screening also, that will.
In that screening committee,
If your lordship is pleased to give a time bound, in a time bound manner, lordship, so cause and screening. Then lordship, I think lordship the petitioner will be able to place their case, lordship, instead of pending. Keeping it
Okay.
pending lordship. And lordship may kindly take note of that, that our regulation order, lordship may kindly take note of lordship.
all his
Regulation order,
submission, he
only
may
that
submit a copy of this petition along with the
Yes.
reply to the so cause notice if
No,
ever
no.
issued to him. So
No, no,
difficult.
every application must be individual.
Yeah, this screening lordship will see consisted of 8,470 members, different screening zones.
So the,
Once we take up his case individually, he will have every opportunity of putting up his individual papers. And that will be looked into individually then by the competent authority director, without anybody there being in the middle. There'll be an inquiry officer, there'll be him and the appointing authority. He'll have all opportunity. But if, as of today, we are to place it before this honorable court, there will be always some question of dispute which the department will bring up, and
And
his
lordship, that-
application is not traced out, he has not given this, not that. This letter number is not with us. It is not issued by the DIS office. All those issues, the government will be able to take up before this honorable court. Once
and-
we give him a show cause notice, it is only on that show cause notice he has to reply. He will not reply to anything else.
just a moment. Let me understand what you are trying to say.
Madam,
Am I to accept your submission to be one that if he responds to the show cause notice,
yes,
the objection as to whether this applications were submitted and all, those would not be raised. And you would go only by the show cause notice and the
Yes.
reply.
we cannot go beyond the show cause notice. That is how a person has to defend his termination.
Okay.
If in the show cause notice itself we say that we do not have a copy of your treasury challan being submitted to us, then he will reply to it. If the show cause notice does not contain that, in our final order, we cannot take that to be a ground. It has to be limited to whatever was there in the show cause,
Okay.
or what was inquired into.
And lordship,
Means-
page
That is
62
what-
order basically is in regard to lordship, Lakhimpur and Dhemaji district. In fact, lordship, in Nagaon district, there was no screening at all, lordship. We are not subjected to
So in
screening,
all,
although we have challenged. They have
taking a
found
cue
only
from that,
one
if
teacher.
Nagaon was never in question, he will not be served a show cause notice. That is why I am asking for a time frame to be given by this honorable court so that we can take it up as soon as possible. We concentrate on his case in the next 1 month or 45 days. So if required, we give a show cause notice. If not, he continues. At least some stability will come to his service.
So, after the 6 weeks, there will be a quietus to that issue. And
Yes,
then-
has to be under orders of this honorable court.
Lordship, may and only note the fact that Lordship, we are regularizing service, Lordship, annexure one for Lordship, may kindly take.
All his time here may be taken up as his submissions. And then the
Or
matter.
regulation order and Lordship, till Lordship, decision by the Lordship, the authority Lordship, our services should not be, that interim protection may also be given Lordship. Since now they will go to.
Okay, here's the order.
Madam.
Heard Mr. S.K. Das, counsel for the petitioners, and Mr. R. Mazumdar, and standing counsel for the Secondary Education Department. This is elementary.
It will be elementary.
Elementary Education Department. Appearing for all the respondents.
Lordship, page 5, paragraph 3, I have given the details. Lordship. So I have given a chart. Page 5, paragraph 3. Lordship.
In brief, the case of the petitioners is that the petitioner number 1 was appointed on 12/8/1992 in Kawai Mari ME Madrasa, page 5. No? And the service was regularized by order dated 15/9/1999. The petition number 2 in the chart, we just add those 1 to 6. Full stop. It is projected that the Elementary Education Department had conducted a screening process pursuant to orders passed by this court in WPC 1457 of 2010. To find out as to whether whether there was any irregular or illegally appointed teachers during the period 1991 to 2001, more particularly in several districts, including Nagaon. It is projected that in the screening process which was undertaken at the district level, correct?
At the district level, there was a zonal level.
Okay, district level,
Divisional
zonal
level.
level. Then
Initially, it was a district, then it was divisional.
it's a divisional, then zonal. Three process.
Screening process,
No, 3 process.
3 processes.
And the authorities had arrived at a decision that several appointments were made during the ban period. Some of the appointments were made by the school managing committee. Some appointments were made against non-existent posts. And in certain cases, there were no record of valid appointments. Thereafter, by the impugn order dated 13/7/2018, the Commissioner Secretary to the Government of Assam Elementary Education Department had directed the Director of Elementary Education Assam to issue individual show cause notices to (8470) candidates, including and 766 candidates, including 752 terminated teachers in Dhemaji and Lakhimpur districts, indicating therein the reason as to why their appointments are deemed to be illegal or be irregular, and why they should not be removed from service for being so appointed in violation of the existing rules. Next paragraph. The learned counsel to the petitioner has submitted that in the impugn order dated 13/7/2018, although there was a reference of illegally appointed teachers in Nagaon district, but in the operative part of the said order, the Elementary Education Department proposed steps only in respect of Dhemaji and Lakhimpur districts. And the said order does not refer to the case of the petitioners. And then it does not predict that the petitioners in this writ petition were appointed illegally or irregularly. Full stop. The learned counsel for the petitioners has emphasized on the copy of appointment orders and order of regularization of service of the petitioners, which are next to this petition as Annexure 1 series. Accordingly, the petitioners have prayed for setting aside and quashing the order dated 13/7/2018, issued by the respondent number 1 in respect of Nagaon district, and for a direction to the respondent authorities to release the pending arrear and current salaries of the petitioners, as their services were regularized in the year 1999. And for a further direction to the respondent authorities to permanently absorb the petitioners as assistant teachers in their respective schools. Next paragraph. Per contra, the learned standing counsel for the second Elementary Education Department has submitted that despite directions contained in the impugn order dated 13/7/2018, due to pendency of this writ petition, no show cause notices were issued to the petitioners. So it is submitted that as large-scale anomalies have been found in appointment of teachers during the period 1991 to 2001. It is imperative that screening be done in respect of the petitioners, because in the previous screening, process. My last year anomalies have been found in appointment of assistant teachers in various schools. So, on a query of the court, the Dynamic Standing Counsel for the Elementary Education Department. Submits that if the court permits the respondent authorities to go ahead with the directions as contained in the order dated 13/7/2018. The department will be bound to complete the process within a time bomb manner. Subject to condition that the petitioner cooperates with the exercise to be undertaken by the Director of Secondary Education, Elementary Education, Assam. Correct, Mr. Mazumdar?
Yes.
Next one. On a query made to the learned counsel for the petitioners, he also expresses that the petitioners do not mind to cooperate with the exercise to be undertaken by the respondent authorities, subject to condition that the matter be brought to its logical conclusion within a time-bound manner. And that till a final decision is taken, the authority should not terminate the services of the petitioner. Correct?
One thing I forgot to mention, Lordship, annexure 2 poly page 27 to 33, we have been given working certificates till the time of filing the writ petition of 2018 by all the headmasters of the respective schools,
Okay,
and
it is
including one
submitted-
in
it is
which
submitted
Lordship
that
the
the
locally.
petitioners are working in their respective schools till date.
Annexure
Next
2
one. In view of the submissions made by the learned counsel for the petitioner as well as the learned standing counsel for the respondents. Court is inclined to provide that in the event the Director of Elementary Education, Assam, issues individual show cause notices to the 6 petitioners herein. The petitioners would respond to the allegations made against them. First part against them, the said show cause notices should be issued within the outer period of 4 weeks.
Lordship considered 6 weeks, my lord. Lordship will give us 6 weeks, my lord.
So to issue a show cause notice.
My lord, because 8470 persons, each one's file has to be taken into account.
No, I'm not on others. I'm only respective. That's why I'm specifically
them.
saying for 6 petitions. I'm not
Let
referring
it
to
be
others.
for 6 petitions.
6 petitioners. For the 6 petitions, within a period of 1 month from the date of receipt of certified copy of this order. To stop. The petitions will be given sufficient time of about
Another 6 weeks.
No,
Or
4 weeks.
another for 2 weeks also. After 6.
4 weeks time to,
4
to submit their show cause reply. And
1 month.
thereafter, the authority, the competent authority appointed by the Director of Elementary Education Assam shall give an opportunity to the petitioner of personal hearing and make an endeavor to dispose of the proceedings arising out of the proposed show cause notice within outer period of 3 months. Next one. The respondent authorities, including the Director of Elementary Division Assam, is expected to adhere to the time schedule indicated in this order. Next one. Till such time the decision is taken by the competent authority under the Director of Elementary Division Assam, the petition shall not be disturbed from their service. Just they decide the matter within the 3 months thereafter, including their decision for payment of the area and current salary of the petitioners. Next one. With the actions as contained herein, this petition stands disposed of. For the learned standing counsel for the Elementary Education Department shall transmit a downloaded copy of the order to the Director of Elementary Education Assam. Next, but it is clarified that this order shall be effective only for the present 6 petitioners.
Also, we will also file a representation and a copy of it.
I have given that opportunity. You file a show cause within 4 weeks.
Yes.
And then I've given you an opportunity of personal hearing.
Also, in the second petition, also there are 10 petitioners, and also the cert is given in paragraph 3. Other order will be same.
Para 3.
Page 5, paragraph 3 also.
Page 5, para
The
3.
details of the petition.
10 petitions.
And also the working certificates are also given also.
Okay, I'm not referring to those certificates, but I'm just mentioning that you are there. Only 2 matters.
Only 2. This program. Published.
This always require 10 petitions. Next please.
Obligation.
17.
Please, just a moment, Mr. Mazumdar, there was one more matter where your presence is required. It was item. So Mazumdar, 12 and 13. 12 and 13 are your matters.
Just disposed of.
Oh, only this one matter. Okay.
Here I prayed for some accommodation today, we are to file an affidavit in reply,
Affidavit in reply. Okay, on the both sides are represented, on the prayer made by Mr. P. Middle and counsel for the petitioner. Matter they don't do anything to have affidavit in reply in the matter. List after
10 days.
List after 2 weeks.
Obliged.
19.
Obliged.
May I please your lordship? Lordship, PLC has already considered. PLC is already considered lordship and SLC also considered in grade 4 post. But that it's challenged by petitioner lordship for review of the SLC. Already considered in grade 4 post.
Okay, yes,
I want some time. Yesterday I received the file. Earlier, P. Soikia was in this matter. So,
Acha, okay. You made a prayer in the morning. And adjourn the matter, she's praying for an adjournment.
all ways to do this.
All sides are duly represented. On the prayer made by Ms.
I'm Rasul.
M. Das, and counsel to the petitioner. Matter stands adjourned today. Let's start answering view vacations.
Good night.
Not with item 19, name of GA Assam may be shown, my lord.
Okay, the registry shall reflect the name of G. Assam in the causes by listing the matter next. Yes.
Letter pertains to regulation of service. Petitioners have come from group, my lord, illegal and irregular teacher, my lord. And the petitioners applied pursuant to advertisement, my lord. They are submitted, my lord, working certificate, but in the list published, my lord, they are not shown to be working teacher, my lord. So similarly, situated person is obviously approving our report, my lord. Petitioner will put pass another, my lord. For reviewing. You are allowed to submit representation to the director, my lord, and director will consider.
ME schools are under the elementary education. Yes.
Khatonia was there. Or given a copy to Mr. Khatonia. There are 10 minutes left.
But just a moment. You are referring to this judgment in your application, in your petition. I did not find the application.
We file application there.
No. In the screening committee, did you file your applications and then?
Yes, sir, yes.
Where are those applications? I did not find it.
And finally, similar,
Where is your original applications to the authorities? Where is that?
working in my lord, Talan is there, my lord. Case,
No,
my
no,
lord.
Challan is there, but you see, Challan is.
Case 54, my lord, onwards.
No, that is okay, but you see. Since I come from the civil court background,
My lord.
you see, everything I correlate, when you are speaking of anything, I correlate it with the civil proceedings. You see, a tenant deposits challan in the bank in favor of the landlord, but does not deposit the challan in the court. He becomes the defaulter.
One thing is case 73, my lord. After submitting application, my lord, they issued notice to me, man, to appear before the screening committee.
73.
Case 73.
Ah, yes, okay.
Case 73 onwards, my lord.
Okay.
So we accordingly appeared, my lord, and submitted working certificates. But our name not included in the list of working teachers. And they have already regularized more than 4,000 in the 2021, my lord, among the group from the regularized teacher, my lord, working teachers, my lord. So our simple, we will expose report the, my lord, director, my lord, filing our relevant document. Director will be considered, my lord.
You see, there are difficulties when you make me read the documents. For example, one document at page 88. This is a certificate of 1/4/2018.
Yes, my lord.
That means this is post verification.
Yes, my lord. Earlier, we stated, my lord, at the time of my lord, scrutiny, my lord, we have submitted the certificates before the steering committee. Thereafter, we have obtained this certificate. Since we are continuously working on it.
Okay. Yes, Mr. Mazumdar, then they are covered by this judgment.
Yes.
This is
I
part of
can
the same
make the
order.
representation.
Had Mr. H.R. Ahmed, learned counsel for the petitioner. Petitioners, how many petitioners?
51 members.
Yeah, for the petitioners. And Mr. R. Mazumdar, and it's standing counsel for the Elementary Education Department. We're picking for all the respondents. Yes. The in brief, the case of the petitioners is that all the 51 petitioners were appointed in different middle. What is
Middle English school.
Middle English School of Morrigaon district between 1991 to 2001 by the managing committee of the said schools. And by referring to the school certificates, it is projected that the petitioners have been rendering service in the respective schools from the date of their respective joining till the date the certificates were issued. Full stop. The authorities were of the opinion that various assistant teachers in the ME schools were appointed between the year 2001, 1991 to 2001, divorced the rules. And therefore, pursuant to directions contained in order dated 2/3/2010, passed in WBC 1048 of 2004, the state was permitted to frame a policy for regularization of the teachers However, liberty was granted to appoint to identify the teachers on field verification to be working. Full stop. First off, it is next para. It is projected that pursuant to the screening process initiated by the respondent authorities, the petitioners had made an application to subject themselves to the screening process, pursuant to which the petitioners were issued call letters to appear before the concerned authorities with requisite documents as mentioned in the notices issued by the district elementary education officer. So it is submitted that although the petitioners had produced the working certificate issued by the respective authorities of the school, by the authorities of the respective schools, the same was not considered and the petitioners were placed in the category of illegally appointed teachers. Next, the Learned Council for the petitioner. The petitioners has produced a copy of order dated 5/11/2019, passed by this court in WBC 94 of 2019. And it is submitted that by virtue of the said order, this court had directed the authorities to ascertain the claim made by the petitioners as to whether they are working or not. And it is submitted that as the petitioners are similarly situated, a similar direction be issued in terms of order dated 5/11/2019, passed in WBC 94 of 2019. So that the authorities in the elementary education department can re-verify as to whether the petitioners are working or not and take an appropriate decision. First of the relevant observations in the said order is extracted below. This order para 8 to 12. Next para. The learned study for the elementary education department. Submits that although the petitioners have been found to be illegally appointed, but in view of the order dated 5/11/2019, passed in WBC 94 of 2019. The authorities in the elementary education department be permitted to make a field verification as to whether the petitioners are working in the respective schools or not, and then to take an appropriate decision. Next. Accordingly, the court is of the considered opinion that it would be appropriate to grant an opportunity to the petitioners to make a representation before the Director of Elementary Education, Assam, along with a certificate copy of this order and all the testimonies that they are having. Such a representation shall be made within a period of, you actually make it 10 days?
2 weeks, madam.
2 weeks. Okay, within a period of 2 weeks from the date of the order. So on such representation being submitted, the Office of the Director of Elementary Education, Assam, shall acknowledge the receipt of such representations from the petitioners and upon consideration of the and its designated authority shall consider such representation along with the supporting documents as produced by the petitioner and take an appropriate decision. Thereon, it will be open to the authorities in the elementary education department to inspect the respective schools of the petitioners. This one. In the event, the authorities find that the petitioners though not directly appointed, but are found to be working in their respective schools. They would take a decision regarding regularization of services in terms of the order dated 2/3/2010 passed in WDC 1048/2004. The authorities in the elementary education department shall communicate their order to the petitioners in their respective email addresses to be provided by the petitioners. Correct? It should be emailed to them. The decision should be taken within a period of 3 months.
3 months.
The decision to be taken by the authorities in this answer within an outer period of 3 months from the date of submission of such representation by the petitioners.
Perhaps he will.
Okay, Mr. Paywood and Government Advocate, I can respond number 1 and
Respond number 5.
okay, 1 and 6.
1 and 6.
And Mr. A. Shalia and Mr. Nichols for respond number 5. Mr. Shalia, yesterday in the matter we imputed finance. Please take the case number from the master. It's an old matter and very bigger amount.
38,000.
38,000 rupees. For that, the petitioner is running for last 7 years. So I deemed it appropriate to impede the finance department so that this cumbersome process of getting a non-disbursement certificate, non-withdrawal certificate from the treasury. These are
Non-drawn certificate is not issued by the treasury.
then
Issued by the DDO. The non-drawn certificate is.
Treasury officer is not even heavily. Actually, treasury officer does not have the records because of which he cannot issue the non-drawn certificate. It has to be issued by the DDO, my lords. And on the basis of the non-drawn certificate, the treasury officer can release the amount, my lords.
no, but then you see, I'm just trying to understand.
Yes, lord.
If that be the case,
Yes, lord.
let us take an example of example. A person comes and tells us he agitates a grievance that his salary is not being paid.
Yes, lord.
The respondent is represented by their standing counsel or the government advocate,
Lord.
whoever. They don't dispute that the amount has been withdrawn by him. Therefore, why we need a certificate? Why does the adjudication of a court needs a certificate that this non-drawn certificate be given?
So that is only for the satisfaction of the treasury officer that that amount has not been withdrawn, my lords. Only for that confirmation they need it, my lords. It's according to the rules, my lords. That only even if they're not done, if that certificate, the treasury officer can release it, my lords. Their treasury officer is not the authority to verify. They just release on the basis of the instruction that is forwarded by the administrative department.
But you know, very strangely,
Yes, Lordship.
there are few living beings who eat their own, what you call, own tribe. You are aware of it?
No, no.
There are few living beings,
Oh, cannibals. Yes, Lordship.
no, not cannibals. There are few other living beings
Lordship.
in the world. There are hundreds of varieties, like fish eating a fish.
Yes, Lordship.
Correct. There are many small, many living beings who eat their own community.
Yes, Lordship.
So supposing a man for 38,000 goes to the office to have a certificate, can you tell us the expenditure which he'll incur in getting that 38,000 non-roll certificate?
No, Lordship, that I am not disputing. Lordship, the main issue is the treasury officer. Lordship, I have come across such cases where the treasury officer says because there is no non-roll certificate, he cannot issue it because he is guided by those rules, my lord. Those rules are binding. If he gets he is not disputing whether or not they're entitled.
But that's what I'm asking you.
Now
What
that
would-
is.
What would be the average cost?
His hands are tied, Lordship. The treasury officer in so many circumstances, they want to release the amount, but because of these legal issue technicalities, my lords, their hands are tied, my lords. Otherwise, if non-roll certificate is the only
Because you
issue.
must understand, if a person is from 2016-17 running to court for 38,000 rupees,
Yes, Lord.
you must understand,
Lordship,
the authorities would have to understand
That is,
why these people are waiting for in the court rather than
Lordship,
for 38,000 engaging a lawyer,
yes, Lordship.
correct? Coming to court, paying court fees, waiting for 6, 7, what you call years.
Lordship,
for
I
38,000
have seen
rupees.
cases where the treasury officer is pursuing for the petitioner, my lords, so that the petitioner, so they write different letters to all.
But those are rare breed.
Yes,
If
Lordship,
there is some
treasury
officer, I would like to appreciate them.
Lordship, I've seen the conduct of the treasury officers, they are very, they bow down in front of all the court's orders, my lords, and they want to comply with each and every, but there are these issues these legal issues because of which they can't, and most probably they have already written to the DDO regarding the non-roll certificate because these are legal technicalities, my lords, which they are binding upon the treasury officer, my lords.
The only experience I had in the treasury was in one of the cases I was appointed an amicus curiae. At that point of time, I was a young junior. And then I was standing in the treasury. And suddenly one office peon from the district judge establishment, he saw me standing there and said that, why you are standing here? I said that for so and so amount, about 3,500 or something. Said that, no, why should you stand? And then he took us to the treasury officer and he projected as if I was a very big shot. Correct. And he was addressing me like, sir,
Yes.
this, sir. And he took away a chair from there. Sir will have to sit. Then all that paraphernalia, and I got the treasury certificate within 10 minutes.
Yes, Lordship, that's.
But that is the only experience I had.
Yes,
And
Lordship.
thanks to that office staff that I was respectively given and disposed of within 10 minutes
Yes,
by
Lordship.
the treasury.
Most of the cases, Lordship, the treasury officers are not aware what is going on in the court. Only after we communicate, they become aware, and then they're also running pillar to post, my lords, after.
Okay, but that order I have already signed. In that order, I have mentioned that if required, you will direct the
Lordship,
treasury officer for it.
Lordship, according with the treasury. that is-
No, but that order you just
Yes,
tell
Lordship.
the authorities that it is meant for the department.
If we have to issue it, my lord, as he says now, the DD has to issue, and what was the DD issue?
Lordship, because they have the records. They're.
Okay, this part I was not aware, so I made a mention that
Lordship,
non-roll certificate be issued by the finance,
treasury officer.
no, the finance department shall call for the non-roll certificate from the treasury officer. That's what I said. in the order.
Lordship, I'll re-clarify, Lordship.
So if required, bring to the notice of the court, we'll amend the order.
Lordship. No, once the president.
My lord, I have small pair, my lord.
Yes.
I have 3 cases in this court, my lord, 2, 4
So then
and
the pair can't be small.
my lord, 2, 4 and 22. Actually, I'm not keeping well. So I
You're
need
not well.
28 April. 28 April.
Okay, her item is K Devi, the place for adjournment. She's not feeling well. You're there for the
Odindari is there.
22.
She's unwell.
Okay, in 22, you write Mr. C. Goswami for the private respondent
Yes, respond.
is present. Okay, matter adjourned today, list transfers. Okay.
We have included one of the parties.
They refuse to accept.
They said that she was not working in their school. Being public higher secondary school. Said respondent was not working in the school. it opened. An inspector of school, Naga Circle, they refused to give any information regarding it.
Yes, Mr. Pegu. If the SLC has recommended her name, where is that SLC, which page?
SLC, my lord,
No,
DLC is
to you.
recommended. DLC, minutes of the day.
SLC, you said recommended number 8.
Yeah, SLC is recommended.
So where is that page, relevant page? You are supposed to get that, that address there. Where is the relevant entry of respondent number 8?
page number 28 of the repetition, my lord. Or respondent number 8, its
28.
That is DLC.
address is not given here. Srimati. नाम तो किसका respondent है ये?
Yes, what is the way to get her address?
The school on respondent number is appointed in a particular school, my lord.
That school has informed us that she was not working in the school.
She is not working. But you see, I'm asking you for a particular reason. This page 28, which Mr. Pegu has shown me, you see, I've already flagged this. Correct. Page 28. The reason I'm asking is that against page 28, it is written not recommended.
Not recommended.
Then
SLC has selected one. DLC has not recommended lordship.
so show me that SLC then at page 23. Page 23 is that DLC.
This is not the manager.
It's annexed in the affidavit in reply, my lord, that SLC pilots.
Okay, where is the entry?
Page number 17 of the reply, my lord.
Page 17.
Filed by respondent number. By the petitioner, my lord.
That is rejected due to non-availability. That is Jitu Tapan Das.
My lord.
No, I want to know about this respondent number 8. Okay, that name is at page 11.
Page 7, my lord.
11 of the affidavit.
11.
Being public HSS.
But the thing is that date of the minutes, SLC, DLC minutes, my lord. DLC minutes 9/8/2012, the respondent number 8 was rejected, my lord, but was recommended in the DLC minutes dated 23/4/2013. In the next year, my lord. Page 11, my lord.
23/4/13.
24/13, my lord. But earlier in 2012, she was not recommended.
This is Inspector of Schools, Nagaon. So we will direct the inspector of schools now to find out whether this pursuant to page 11, where has the respondent number 8 been adjusted? Correct. She says that she went to the school and they said that he's not working in that school. Okay. But have you filed an affidavit to that effect?
Yes, Lordship, we have filed one affidavit on justice and. Yes, Lord.
You have filed. When did you file it?
31st March.
Huh?
31st March.
31st March. But I don't think it is there on record. No, it's not there.
No, they-
Okay. Also, is it really represented? Miss
Yes, Dev.
L. Dev,
Yes, Dev.
S.
Yes.
The counsel for the Krishna submits that on 31/3/2023, an affidavit of Dasti service has been filed. So the said affidavit is not on record. The registry shall track and tag the said affidavit on record. Next, in the meanwhile, as it is verbally submitted by the learned counsel for the petitioner, that the petitioner had gone to the DHING Public Higher Secondary School, Dhing, Nagaon, to serve notice by way of Dasti on respondent number 8, namely Srimati Jyoti JYOTI Rekha REKHA Saikia SAIKIA, who as per the SLC decision taken on 26/3/2014, right? What is the date? DLC?
DLC
SLC page 8. I can't read that.
26/3/2014.
This is 3/2014.
26/8/2014.
Is it 8?
8, my lord.
I don't know. I can't read.
It's not clear. It's probably 8, my lord. It is 8/8.
It's in the second paragraph.
26/8/14.
First paragraph, Lordship.
Huh?
It's in the first paragraph, the meeting of.
Yes, madam. The first paragraph, the names, madam. Members present. 10, my lord.
The meeting
So
of the-
26/8/14.
Yes.
Okay, 26/8/14. On the respondent number 8 was recommended against vacancy at Dhing Public HSS during 2013. So therefore, the learned standing counsel for the elementary education department, elementary education department, Mr. U. Sharma, learned standing counsel for the elementary education department, shall obtain instructions from the concerned inspector of schools, Nagaon District Circle, as to the school as to this name and address of the school in which Srimati Jyoti Rekha Saikia, within bracket respond number 8, whose name appeared at serial number 34 in the DLC minutes of 26/8/2014, was appointed. So, in order to enable the learned standing council for the elementary education department to obtain instructions from our learned council for the petitioner shall provide a photocopy of the SLC minutes of 26/8/2014 to to provide him with a copy of so-and-so list after how much time? 3 weeks? List after 3 weeks. You give a photocopy to him. Otherwise, he'll not be able to follow it up.
24. 24.
Yes,
Contempt petition, my lord.
Last order, Lordship, 27 to 2020.
yes.
Well, I have received some instructions, but I do not think they're appropriate. I have reverted back to the department, so if you give me time till the around 2 weeks time, my lord, I'll have it corrected. Instructions had come that they are receiving the current salary on the pay scale. But the area salary, there is some department has tried to raise a dispute regarding the whether they would be entitled to a fixed pay or the pay scale. Now, the orders of this honorable court was clear. Therefore, my lord, I have reverted back to them that it is not, you cannot do that now.
Once you understand what the problem is, then there's no difficulty in adjourning, but
This instruction
no,
is
it's
actually
okay.
not correct.
I appreciate that. Mr. R. Sharma and counsel for the petitioner is present. Next, Mr. R. Mazumdar and standing counsel for the this is secondary education. Secondary education department has submitted that he has received instructions from the authorities. But in view of the order dated 9/2/2017 passed in WPC 6569 of 2015, he requires some more clarification. And accordingly, he pays for an adjournment. There is allowed. List on 8/5/2023. By which time the learned standing counsel for the secondary education department shall obtain updated instructions regarding compliance of the order.
Bless you.
So you are appearing as standing counsel or as a
My lord, in fact, my lord, what they do is we have cases allotted to us on contempt. In contempt matters, we are allotted special Wakaladamas we file. But my lord, if someone is in the court, we do not keep it pending. With the instructions come on a group, we have to inform the court. We do inform the court.
No, because you see, I find it difficult. I have been noticing in this bench. You see, number one, if you are appearing without a vakalatnama, I can't bind you. I can't make. I can't through you bind your the contempt now.
Yes.
Correct. If
That
I
is
have to
better.
give some timelines, then since most of you know how I deal with the matter, then you conveniently say that I appear as a standing counsel, because then what happens is that the contemnor is not here, and I am sanguine about this. So I take notice of the provisions of the contempt of court procedure, which is
Yes, sir.
prescribed in
They
the
will-
act. There, unless you are exempted from personal appearance, I have to issue a warrant of arrest and get him.
Yes.
Appear
Yes,
before the court.
that is true.
So I'm finding a difficulty because
Initially, when my lordships had taken up that issue, and I was there in the court that day when lordships first stated that they should be here personally unless the court exempts.
I was,
But you see, this 2018 matters. We have 5 years
yes,
down the line, and these orders have not been complied with.
my lord, if I can state, my lord, what is
No,
that?
no, you see,
Actually.
your personal statement that is okay.
Yes.
But we have to bind this contaminants who are before the court.
But There,
So
there
we-
has been a change. What our attempt is, there has, the contemners who were originally there, perhaps they have also left office, and then he has to impede the new ones, inform them. It takes a lengthy process.
No, what
What
has
we
to be
try to
done,
do
what
is-
has to be done, has to be done. You see,
Yes.
but the fact is that if I can, what you call, pass coercive orders. As far as the contaminants who are appearing before us.
Yes, no, now, in item 24, the persons who are holding the wakalatnama. Mr. D. Mazumdar, my lord, he is no longer with the education department. He had returned the files.
You see, that is my difficulty.
In fact,
Please try to have a discussion in your group,
I'll,
because one of these days till tomorrow, I am not very, what you call, forceful about it. But after, if I'm still taking up the matters post view vacation, then I'll have to insist that wakalatamas are made, and in every case, I'll have to be making a same order, because the contaminants has to be represented by a lawyer.
but here, but in that case, lordship may like to know that the container who's shown in the cause list, my lord, I do not have the file with me, he is no longer holding the post. So
No,
I'll have an
because-
affidavit filed through him, filed by him that he's not holding the post, and what he had done to have the matter complied with. And unless he informs the new incumbent and takes
Because
proper steps.
At least in your group, you can have the discussion, because this is
I'll-
the
I'll-
policy we shall be adopting. Because otherwise, what is happening? 2017-18 matters, contempt are still lying in the court book.
Right. And in fact, we on the entire group, my lord, what we have done is we have tried to go through the court websites. We have tried to find out whatever records we had. We are planning it on the 26th onwards. We should not be standing here without either an affidavit or the instructions on hand, because this
No, that is
court-
appreciated. You see.
this bench
that-
is taking
that
up,
has
my
to
lord, up to
be-
19,
That
and
has
we
to
are
be the
trying to
attitude.
get that sorted out.
That has to be the attitude.
Till 19, we'll have it sorted. Whatever we can have disposed without an affidavit or the instruction on the point of law, my lord, we are trying to do that. Whatever remains by 26th, we are making either the affidavit or the
I'm
instruction.
not expressing any reservations so far as your being is concerned. What I'm on is in the contempt matters, I have to go by the procedure.
Yes,
Otherwise, I'm, what you call, due to my inaction.
here, my lord,
Yes.
the petitioner should be at, my lord, because Mr. Jidung is no longer holding the post of.
No, that is
director.
okay. You bring it on record, we'll dial and.
I'll have an
You see,
affidavit
it's still- It has to be proceeded with in accordance with law.
Yes,
What is procedures if I start violating?
no.
Then at the end,
I will have to-
at the end of the day, when it comes upon you to comply with it, then you say that I don't hold the post. If it can't be complied with. So that's why we'll have to proceed in a manner which is prescribed under the procedure.
From the vacation on, my lord, we'll have proper. I assure.
Because then we'll have this wakaratamas and all, everything.
My lord.
Because naturally, if after 2018, if we now ask the petitioners to plead to amend, all these things will take some time.
Because he has to first inform the present incumbent that this was an order passed, you should take an action. No action is taken, then he can come back to impede, saying that after information they have not.
No, so it's only a delay of 1 month
Yes.
or what, 2 months at best. But the fact remains that the matters are on track as per the procedure prescribed. And I can, as a court passing an order, I can enforce it. The anxiety is that enforcement is now taking a backseat. Okay, be that as it may, you may discuss with your
will have
group
it
so
updated
that.
By the opening, my lord, reopening, I'll have it updated.
25 and 26.
In this case, last occasion, the Stanley Council for the Education, Elementary Education Department took time for filing affidavit.
No, if the affidavits are not there, it's not there. 2018 matters, I am not adjourning just because of that.
21 to 2022 affidavit was took time for filing affidavit. Right. Matters with amalgamation of school.
Now, how can you possibly maintain a order of amalgamation?
No, I have said.
Because the
amalgamation-
orders of amalgamation
Yes.
has been upheld by this court in many cases.
Yes. But in this case, it stays there because there is violation of the office memorandum.
How?
The distance in the school, money, student jail also. That's office memorandum, your lordships. As per which memorandum, it is not annexed.
কি হয় ভেবে স্কুলের হয় না অর্ডারে নেগোশিয়েশন
Because you see,
Lordship. Same
I,
element-
you see, I've just cursorily read it. If you come to page 15, now you're president of this very ME Madrasa. He's he is objecting that on a ground that there is another school of about 500 meters. There's a PWD road daily market between two schools. Enrollment of so and so are more. Number of teachers are less. Therefore, schools are amalgamated. There's a possibility to hamper education atmosphere. How that can be justified? How can somebody say that if the amalgamation is made, it will hamper?
There's a road is there, market is there. And moreover, in this case, both the school, in the two schools is there. Fairberryville LP school and ME school, they are in the same campus. Same way, they jointly approach that both the school, if amalgamated, there is no complaint. Documents are submitted. But it was not considered. Instead of that, they have filed into order. The amalgamated school, that Ansaric High School. which is-
To justify how you are saying that it will not be there. The educational will hamper.
But it's additional guideline also, where those school has 4 students enrollment, that's amalgamated to another school. But in our school, enrollment is more than 400. Enrollment. In both the schools. Let them file affidavit. We'll reply.
No, if it is not required, you can justify and we'll allow that.
So in
If you
para-
can
page-
success.
Page 6, you also can see. Of my petition.
Page 6 and
Page
there,
6, para 4.
para 4.
That from the date still till today, the internal students in the madrasa has been increasing day by day. Presently in 3 classes, madrasa 7, 8, 6, 7, 8, with enrollment 338. Just in classes 129, 127, and 20. Yes. And as per which manner in those schools less than 15, ME school. Paragraph.
So your school has 3 classes.
3 classes.
6, 7 and 8,
6, 7 indeed.
correct?
Correct.
And now your enrollment in these 3 classes is 338, right?
That's
Now, under the this Right to Education Act and this rules, how many for how many students there can be one section?
section is not there. 30. Means
I think 30 or 40.
Yes.
Let us say 30 and 40. So even if you take it is 40, that means 40 will be about more than 3 classes, 3 sections in every class. So are 6 teachers competent to teach so many sections?
That's it. That's if you adjust then another amalgamate to another school, then it will be increase. That's a difficulty. Where less enrollment is less as per memorandum. The government has taken decision that enrollment is less. Some schools enrollment is less, but teachers are more. That is amalgamate to nearby school. But in ours is different. That's why quota is there. Because its enrollment is.
No, no, you see, the process of amalgamation is that it must be amalgamated with a higher level of school.
I used to be at the nearby school. Yeah, let's say if there is two school, then adjust is to one, 100 to 100.
So what is the difficulty? What is the practical problem? Just tell me the practical problem. How do you suffer? If let us say school A amalgamates with B and becomes B, how is A materially affected?
Affected your we have state area ownership.
No, you see, I may have objection if the government now wants that this MG road be renamed as XY road. I have objections. Correct.
Correct.
There was a lot of hue and cry, but the name of Guwahati was changed to Guwahati. And nobody was affected later on. There are objections, we have dealt with objections. If the authorities decide that there should be one new post office in that area, it will cater well. Against that also, there is a representation saying that if my PIN number changes, people will not find me. So objections are there. You may have objections because
In this case, if they shifted to another school, there is a market. You should to cross the road and market. That's it's more the same thing, and they should. It is difficult for them to cross the market and the area, daily market also. Their road is.
students will difficulty. But don't tell me that. I live in the busiest market area and I used to do my schooling from that market area. There are two major schools in that market area where I spent my childhood. One is LOG Hindi High School. Even you can't walk in the road properly at times. That is one. Second is Balika Vidyalaya in Kedar Road, where with the amount of what you call traffic and commercial activity is highest.
You know that they said they are the same campus.
Same, you see, Pamjar, there is Girls High School, then there is a Don Bosco High School,
It is there.
then there is Collegiate School,
Town area,
Cotton College, in the midst of a heavy traffic. Till the other day, university was operating in a high state highway. Now the roads have been bifurcated. Earlier, even the Guwahati University was under what you call that location. Tezpur University is located in the busy road. In this large country, do we have answers for everything?
because it was because this, you know, it was mentioned that it is the same campus in the high school, but not campus. At every street.
Because you see, I don't know, it's just because of the background, maybe you don't, you will not understand the perspective when, where I grew up. I may not understand your perspective where you grew up, in which environment you grew up. Because you see, ours was a place where perhaps my parents should say, okay, you are going to school, while coming back, you go enter in the market, purchase these items and come back. And we did that. In the school time, we were happy to have 5 or 10 rupee note in our pocket, so that while returning, I could purchase something and come back. So 10 rupees in my pocket would make me a king in the classroom, because nobody had 10 rupees in the classroom, except 1 or 2 few privileged people. So having 10 rupees in the pocket was a good incentive. No, I will ask my mother, yeah, want me to bring anything from the market? It's only a perspective. If you change the perspective, you think differently. I may not understand that perspective in you.
Also, distance also there.
But amalgamation of school, how can you possibly, because you have to show something, demonstrate something more. Merely because you think that it would not be conducive. because I'll tell you, there's a change in perspectives. Few days back, our earlier Chief Justice, Honorable Chief Justice had inaugurated Vidyarath. In Vidyarath, what happens is that the schools classes are being held in the vehicle. You have seen the vehicle, Vidyarath. At morning 10 o'clock, you will find this Vidyarath crossing the High Court campus, traveling to somewhere to Nunmati. Every day at 10 o'clock, you will find it crossing 5 minutes plus or minus. This school bus does not have a sitting arrangement. There is a floor where you can sit. In the Vidyarath, there are decorative what you call items placed so that the children, these are meant for school children, street children who are given education. So they are collected from, all the street children are collected from various traffic points and they are taken to a particular school. There they are given the midday meal, given education, and they are returned back. And it's a duty prescribed of the teachers that they would also use this travel time to educate these street children. So now we have a school concept where even in traffic, you can, midst of a huge traffic, you can still teach people, students, something they are taught. So Vidyarath, you will find a yellow school color bus. 10 o'clock, if you stand in front of the High Court gate, you will find Vidyarath going out. You just go in and enter that Vidyarath and look at it. So the concept of the school being a market is not so appealable to me. Yes, Mr. Nanda,
In this particular case, Madam, Lordship will have page 12 of the writ petition.
page 12.
What we have amalgamated, Lordship will see. What are the schools that we have amalgamated? One is the Chenibari, name of the school, Lordship finds.
Just. Yes,
Lordship will find name of the school will be Chenibari Anchalik High School. Now that is a high school.
yes,
Then Lordship will find the amalgamated school is Bhedbari Siddiqui Emi Madrasa.
yes,
This is what we call an upper primary school. An Emi Madrasa is an upper primary school. Third Lordship will find is the Bhedbari Bill LP school.
yes,
Now all these three schools together come under the administrative control of the Chenibari Anchalik High School. Purpose of
Yes.
the government is that we will not have one LP school with some other name under some other management and UP under some other management and a high school. If they are nearby, we bring them, we amalgamate them to have one administration.
but SMCs are not interested in that. They are
But-
more interested in that midday meal
That is why. The
rice.
Lordship will find that the writ petitions are coming up by the SMCs. Because once the LP school gets amalgamated with the ME school and goes up to a high school,
So there's one
the
authority
concept
for a
of
midday meal.
SMPC comes in. The whole concept changes. It is no longer as managing committee. It is a school management and development committee under the secondary education rules. So someone loses bulk of what he was enjoying. And therefore, there is no complaint by the teachers, no complaint by the students, no complaint by their parents. The managing committee is before this. And the moment it was amalgamated, that managing committee was gone. They had no authority to come before this honorable court to say that I am a president or I am the school managing committee. It had to be the school managing and development committee which had to come. Amalgamation will do away with the school managing committee of the LP school and the ME school. The moment it is amalgamated. And here, my lord, we are not asking the school, the children of the LP school or the UP school or erstwhile to go and attend school at the high school. It is the administrative control which has been brought within the high school. They may continue having their classes at the place where it was convenient for them. We have not done away or shut down that school. That building has not been shut down. There is no allegation to that effect. So therefore, my lord, this petition may not.
But you see, there is still one question. Separate set of questions were there from Mr. Islam.
My lord.
But here there is a different set of questions. Number one, you see, as per the memorandum, if the schools are in the same campus, then then it is that as per the office memorandum of 2016, only that then the amalgamation should take place.
There is
So that
another,
what is your
or
answer?
nearby areas is there, madam.
Show me that,
That
because this
that-
is something I did not find.
I'm a little handicapped,
Okay.
madam, I'm not
Okay.
having that office number in the class.
You have the second file?
Yes. No, no, এখানে আছে। ফাইলখন আছে, ওই এখানে।
Oh, office memorandum.
My goodness.
Mr. Islam, where is that office memorandum? You are next it?
No, yeah, but I think those.
Oh, acha. Okay, okay.
At that time, I was not
Okay.
found.
Oh, okay.
Para number 3, my
It
lord,
was 10, 11.
of the 2016, 22nd of September 2016, para 3. After carefully consideration of all aspects and with a view to derive optimum services of employees and other logistic support of the schools, it has been decided that the schools situated in the same campus or in any nearby area shall be amalgamated or merged, and all the schools shall be amalgamated or merger of different schools. The following criteria should be considered for each amalgamation or merger. So that here, all the schools situated in the same campus shall be merged. If there are two schools in the same campus, they shall be merged. It does not say that nearby schools we will not take into account. Then other high school or ME school of all these situated in the same campus, all other schools shall be amalgamated with the higher secondary school. Likewise, if the high school is a high school, then all other schools subordinate to the high school shall be amalgamated with the high school. The SMDC of the so-and-so shall continue, and SMC, SMDC of all other schools shall stand withdrawn. That is where the pain starts. Then lordship will find
That's.
This is,
Criteria
this is
take-
apparently a public interest.
yes.
Criteria close 10, 11.
Criteria 10 and 11.
10, 11.
Yes. If a ME school has poor enrollment, less than 15 students in each class, then the ME school may be merged with the nearby high school. That is one of the conditions that we may take into consideration. If two or more LP, that is ME schools, are located within the radius of 1 kilometer, then these ME schools may be merged provided that the number of students does not exceed 40 in each class. If two or more LP schools are located within the radius of 1.5 kilometers, then these LP schools will be merged provided that the number of students do not exceed 100 in each school.
So if it exceeds 300,
Marvelous.
then
In fact, my lord, even in those, even in the case of provincialization of schools, if lordship, the Act of 2017, we had a concept of a base school where the provincialized teachers were being taken, all the students. The entire post concept was on a base school. The government has taken a conscious decision that even after merger of the other schools in the base school, the erstwhile school building and the school where we are not disturbing that. We have given we have created one school which will now control the entire administration and the property. The concept is not to create trouble for the students. The concept is that we should have one head where one school will cater from LP to the highest possible level. Now, in this particular case, lordship will find that the LP school has been amalgamated with a ME madrasa. ME madrasa is a middle English madrasa. Middle English madrasas are those where the extra subject of Arabic comes in. Otherwise, it is an ME school. So what we try to do is students studying in the now Chenibari Anchalik High School may start at class 1 in the same school, will continue up to class 10 in the same school. He will not keep changing his school names. The administration will not change. From an LP, there will be no question of going to an ME madrasa. He'll go from class 1 to class 10 in the same high school. That is the concept. We are not, there is no allegation that the children are being transferred to and requested to go to Chenibari Anchalik High School.
okay.
Therefore, I love this petition.
Okay. Heard. Mr. S. Islam, counsel for the petitioner. As well as Mr. R. Mazumdar Leonard, standing counsel for the Elementary Education Department, appearing for respondent numbers for all the respondents, even the headmaster, anybody. Okay. For the headmaster also, you will be appearing. Mr. Mazumdar, appearing for respondent numbers 1 to 5, 1 to 4, and 6 to 9. And Mr. G. Pegul and the government advocate appearing for respondent number 5. The petitioner is the school managing committee of Bheri, BHERI, Siddiqua, SIDDIQUIA, ME Madrasa. And it is represented by its president. First off, the said school was established in the year 1969 and was provincialized with effect from 1/3/1978. First off, the Secondary Education Department provide office memorandum number capital ASE -481/2016/18.
My lord, may I take leave?
It's not 18, it should be 17. Is it a typing mistake in this synopsis? So not synopsis, you are synopsis 18A you have written. It should be 17, I think. Because in page 12, 17 is mentioned.
It is 17, repetition is 653, 17 no. Repetition filed sometime in January, so it should be
17.
No. Issue number.
Memo number 17.
Issue number, third line of page 12. (481) 2016, 17, page 12.
Yes.
Sir, with so and so, third line, fourth line, number ASC so and so.
No, your lordship. That is different. It is
That is the OM data.
It is different order.
No, I'm referring to OM, but in synopsis it is written 18A, which is right.
18 is the original office memo issued by this one here.
Here it is 17.
Last plus 18.
Oh, that is issue number.
Issue number.
Don't confuse the memorandum number with issue number. 17, it should be 17. Dated 22/9/2016.
May I take leave, my lord?
For amalgamation / merger of different categories of school situated in the same campus or nearby area. Full stop. Pursuant to the said OM dated 22/9/2016, comma the Commissioner Secretary to the Government of Assam, Secondary Education Department, had issued an order under order number ASE 1395 oblique 2016 oblique part PT dash 1 oblique 71 dated 19/1/2018, by which Chenibari, CHENIBARI, Anchalik High School, Dalgaon, with DISE code 18080307907, was amalgamated with number 1, page 12, huh? Names are there. Dice code number so and so. And number 2, Bher Bill LP School. Full stop. It was provided that after amalgamation, the name of the school shall be Chenibari Anchalik High School. And the manner in which the SMC oblique SMDC would be constituted was also provided. Full stop. The next paragraph, the learning council for the petitioner, by referring to the contents of OM dated 22/9/2016, has submitted that the enrollment of students in Bherbheri Siddiqua ME Madrasa, at the time of filing of the writ petition was 338 students, with 129 students in class 6, 127 students in class 7, and 82 students in class 8. So it is submitted that the madrasa was running with 6 numbers of teaching staff, including the in-charge headmaster, and that the post of Arabic and Hindi teachers were lying vacant. Full stop. In this context, by referring to clause 3.10, 11, and 12, 10, 11, 12, and 13, it is submitted that as the number of students in the Bherbheri Siddiqa ME Madrasa was 338, the said school could not have been amalgamated with 2 other schools. Full stop. By referring to the representations, the learned counsel, not that, the learned counsel for the petitioner submits that the madrasa and the LP schools are situated in south side of PWD Road, and there is a market in the nearby area, and therefore the students of the market area with almost 200 permanent shops with a footfall of about 2,000 persons. Committee submitted that the students would face immense difficulties in commuting to the amalgamated school. And therefore, the atmosphere for education would be vitiated in the amalgamated school. Accordingly, it is submitted that the school managing committee, by adopting a resolution on 2/2018, had proposed the proposal of the authorities to amalgamate 3 schools into one. Full stop. It is submitted that you are still holding the charge. Yes. It is submitted that owing to interim order passed on 16/2018 in this writ petition, the petitioners are still holding the charge of the school managing committee. Mr. Islam, anything I have left out? No.
The question is some other color is there, 10, 11, it is maybe same distance is there.
No, 10, 11, 12, I have, 10 to 12 I have referred to.
That's the ground.
Next will be Lawrence Standing Question for the respondents. As referred to the contents of office memorandum dated 22/9/2016, and it is submitted that the authorities have taken a conscious decision to the said OM that schools situated in the same campus or in any nearby area shall be amalgamated or merged. Full stop. It is submitted that by the merger of the 3 schools, none of the clauses of the office memorandum dated 22/9/2016 has been violated. First of all, it is submitted that it is submitted that as per instructions provided to him, the intention of the authorities in proposing the merger is that a student who gets enrolled in class 1 of the school could complete his school level education till class 10 in the same school without requiring him to change schools. Hence, it is submitted that except for private interests of the members of the SMC who would no longer be there, would be affected, public interest at large would not be affected. Next paragraph. As postal reliance is placed on subclause 10, 11, 12, and 13 of para 3 of the OM dated 22/9/2016, the said provisions are extracted below. In the present case in hand, The respondent authorities have amalgamated 3 schools into one. So the Sheriwari Anchalik High School, as the name suggests, is a high school. The Bherveli Siddhika ME Madrasa, stated to be equivalent to upper primary school. And the third school, which is the Bherveli Bill LP school, as the name suggests, is a lower primary school. So therefore, this is not a case where 2 or more schools of same category are sort of be merged with another. And therefore, the order of merger dated 19/1/2018 cannot be said to be in contradiction to clauses 10, 11, 12, and 13 of para 3 of the OM dated 22/9/2016. Next para. Insofar as the other concerns which are expressed that the school, that to travel to a school, the students would have to cross a market area with a lot of shops and high footfall. The court is not impressed with the said projection of the petitioner because at least one of the 3 said schools exist in the in a place where there's a market of about 200 shops with footfall of 2,000 as projected. So therefore, if students can, if fewer numbers of students can take education in school with such busy area in the neighborhood, the court does not find any reason why other students would not be able to be imparted education in such an atmosphere. Full stop. There was no public protest on record when the schools and all the markets were established in the vicinity of each other. Full stop. The court is also unable to accept the said submission because if the said submission is accepted, it would amount to the court interfering with the decision-making process of the education department by prescribing the distance in which a school is to be established and run from market area, which would have cascading effect on the existence of hundreds of schools in the state, which are located nearby the market areas or located on a busy national or state highway. These issues should be best left with the concerned authorities in the education department to take a call as to where the schools should be located. Full stop. The only issue with the court is concerned with is whether the amalgamation is strictly in accordance with the provisions of The hearing before referred OM dated 22/9/2016. Full stop. On set parameters, the court does not find that the order of amalgamation is contrary to the mandate of OM dated 22/9/2016. And therefore, the challenge by the petitioners, by the petitioner to the order of amalgamation, the interim order of amalgamation dated 19/1/2018 fails. Accordingly, this petition stands dismissed. First of the interim order which was passed on 16/2/2018. Restrain the authorities against merger of Bhirberi Bill LP School and Bhirberi Siddika ME Madrasa with Chennai High School.
In the Amchari guys.
Was restrained is vacated forthwith. The parties are left to bear their own cost. The second case is of
The Bhirberi Bill LP school.
LP School.
LP school.
Here the petition is LP School, so it will be changing sequence. Okay. So I am coming from the market area background. Was a disadvantage to you. And you know, Mr. Islam, you have triggered a memory which I must share with you. I came from a very humble background. And therefore, since the day I passed my class 12th, I had to sit in my shop and do business while studying. So from class the TDC first year onwards, till I did my LLB, I studied while sitting in a shop, which is in a very, I had a pharmacy and I was selling medicines at Polton Bazaar, which is the highest footfall area for tourists. And I could study and pass out. So therefore, this what you call market area, doing business and studying. You know, everybody used to laugh at me when they found I'm studying in my shop. Except for my parents. Nobody was confident that I could do anything sitting in the shop and doing my work. So that is how life is. And that is why perhaps you'll find that when it comes to medical, I take control over the subject matter is because of that background. Because medical is one thing I still study. I would have been a good quack had I not been a lawyer. That is how life is. Very strange, but this is how life is. Nobody thought that I would do anything. You see, sitting in a pharmacy and selling medicines, and then class 12 onwards, From 85 onwards, I was doing work and then studying and paying for my education. This is my background, so that's why when it comes to market area, I am I couldn't accept your submission. Okay, this is only a personal note.
Obligation.
27.
Yes,
Amount was
Yes.
increased only 54,000. Ordered at 17 to 19 meg and division for a while, my lord.
17 to
17
19.
February 2019.
Not 17, I think 27 to 19.
17 to 19. my lord.
No, 27 to. There's no order of
No,
17
no,
to.
17 to, my lord, 17 February,
There's no order of 17 February.
17 February.
We have order from 18 February, then 27 to.
No, there is an order, my lord, 17 February. There is an order of 2019.
No, I'm sorry, the first order in my file is of 18 to. 18 to says secondary education department is to take instructions. Yes,
My lord,
you have the instructions.
my lord, I have seen the order sheet, 17 to 19. It is started by Mr. Mujumdar, London Council for the Elementary Education Department, that the money has been deposited, has been released in favor of the petitioner in the year 2019, but it is not deposited in his account. The principal of the school concerned is not cooperating for issuing the non-royal certificate, which is causing delay in the petition. It is 17 February 2019, my lord.
Just see this order. I'm not getting it.
I have seen it. Lord.
No, maybe. So, Mazumdar, you have instructions in the matter?
At that point of time, I had the principal of the school called to the office of the IS. They had some discussion, but therefore, since the cost list did not show my name, then notices were issued, but if I'm not wrong, sometime on 16/3/2021. And my name was not reflected, therefore I also lost track of this particular case. As of today, I don't have instruction. I can try to have something else.
Let me find out. Mr. Saika says it's a small amount.
It's 50 something, 54,000 something. Perhaps the principal was not cooperating by, again, the same issue, that non-dual certificate. Same issue. Therefore, the inspector of schools, I had him called to the principal was called to the inspector of schools. So why that particular document is not coming up. Thereafter, honestly, I have not pursued because I lost track of it.
My lord, 17 to 20, my lord, sorry,
Yes, sir.
17 to 20.
Just show it to Mr. Mazumdar. Mr. Mazumdar says he can help in getting
Yes,
instructions.
17. My lord. 19, 20.
Yes, the principal of the school concerned is not cooperating for issuing non-real certificate, which is causing delay in the matter.
Okay.
That was the I was
Okay,
trying.
can you get us information?
Yes,
Mr. Saikia,
My lord.
we give some time to Mr. Mazumdar.
Well-
He'll get instruction because he's aware of it, but he could
and
not
the
follow
copy
it.
of the contempt petition, madam.
Okay.
Copy, a copy দিব
I'll give you there.
মই পঠিয়াই দিব পাৰিম DT, I can give that.
He'll do it.
Yes.
Yes.
Mr. R.C. Saikia, London Council for the petitioner. This contempt petition is filed for non-compliance of the order dated 21/2/2018 passed by this court in WPC 3420 of 2015. Whereby the authorities in the secondary education department were directed to release the director of secondary education department was directed to release the area dearness allowance to the petitioner on or before 31/7/2018 as per his entitlement. Mr. R. Mazumdar, and its static also for the elementary education department, has submitted that although he was not the engaged counsel for the respondents, but as directed by the court, he had appeared on 17/2/2020 and as per instructions received then, although the money was released in favor of the rate petitioner in the year 2019, but the amount was not deposited in the petitioner's account. And he had also received instructions that the then principal of the school was not cooperating for issuing non-drawal certificate, which was causing delay in implementation of the order of this court. So it is submitted that it is reflected in the order, said order dated 17/2/2020, that the department had summoned the principal of the concerned school by the department for doing the needful. So accordingly, he submits that he may be granted some time to obtain updated instructions as to the status of the implementation of the order of this court. Next, by the court. Is inclined to take notice of the fact that this contempt petition was filed on 8/2/2019 for non-implementation of the order dated 21/2/2018, passed in WPC 3420 of 2015, and that more than 5 years has passed by. Accordingly, the learned standing counsel for the elementary education department shall forward a downloaded copy of this order to the to whom?
To the inspector of schools, madam,
To the inspector of schools.
and have the information.
Kamrup District Circle within bracket rural, and inspector of schools, Kamrup District Circle, Guwahati, to obtain information about the present status of the, with regard to the claim of the petitioner. Next one. In the meanwhile, the learned counsel for the petitioner shall obtain his information as to whether the present whether the respondent contemners are still holding the office. And if new incumbents have joined in the meantime, it would be open to the petitioner to to the counsel for the petitioner to put the present incumbents to notice of complying with the order of this court. And then to file an interrogatory application for implementing the new incumbents. Mr. Mazumdar, when?
And the Lordship will keep it after the vacations, my lord, if the
No, give a date, because then the contemners also know.
4th of May, my lord.
Hmm?
4th of May,
We make it 3rd of May,
3rd of
3/5/2023. Mr. Saikia, Mr. Mazumdar,
my lord.
if you can get these three names and give it to Mr. Saikia.
The director would be, my lord, presently M. Hujai. Secondary name.
Secondly,
Director would be M. Hujai,
M. Hujai.
M.
We just
Hujai.
note it down.
and inspector of school would be
This Kamrup Rural and Kamrup Metro.
Kamrup Rural is
Just give it to him.
Apurva Sharma. Apurva Sharma.
Just give it to him. You take the names from him, give them notice and implement them, because otherwise this will not be implemented. And taking note of the fact that your petitioner was 69 years then. Instead of petitioner, I made it the counsel for the petitioner. So you give notice because he will be 73 now,
He is now 74.
74. So we are asking the council to do it. You ask your colleague to give notice and then
Copy of the
Implement.
contempt petition is given to me, my lord. I can forward to them by WhatsApp also. They in the group then.
give a copy to.
I'll give. Well, instead of elementary, it should be secondary division. Secondary division,
Secondary.
secondary, because high school it is secondary division.
It
Director,
will be secondary, not elementary. Okay.
yes,
Second,
oblige my lord.
my lord.
28.
What it is also immediately.
Wait, please, your lordship.
Yes.
Actually, kindly produce the order dated 3/1/2020. Notice was issued, your lordship, and order number 1 to 4 were directed to file an affidavit or place the instruction on record. And as regards respondent number 5, we were directed to take steps through dusty process that we have taken, and we have filed an affidavit also, your lordship.
Okay. So notice on 5 will be served.
Lordship.
Notice on respondent number 5 would be served.
So we have served, your lordship. We have filed the affidavit and was dusty. It's flagged as A
Just now.
for official. Page number 2, your lordship, paragraph 2.
If the instruction. It is.
Okay. Mr. GZ Ahmed, counsel for the petitioner, has referred to the affidavit of Dusty Service filed on 20/2/2020. And it is submitted that notice of duly served on the respondent number 5, who has received the same under her signature on 1/2/2020.
Very well.
None appears on call for the respondent number 5, on whom the notice is deemed to be duly served based on the affidavit of Dusty referred above. Full stop. as the case is reading as a service, list the matter in the admission column after the ensuing due vacations.
Only fixed date maybe again, he's going to retire. It's a promotion.
Okay, give a date.
May. Item number 3.
Ah, yes, this was the case I was telling you that I was requiring you in one more case.
Second copy to do. Second. Oh. Yes. Oh, neither, sir. Not a point. Yes, Madam. In this matter, I had some instruction. I had sent one of my colleagues to the PC school. This scheme is no longer there. No one is working under this scheme in that particular school as of today, my lord. The entire.
You are there, Mr. Ahmed, you are there, the petitioner.
Yes, you're right.
Is it alive?
Lordship, I have to take instruction. I'm not aware. I have to take instruction.
Okay.
Because this scheme is gone. This scheme is no longer in existence. From the department also verbally I've been told them. And the school, I had sent one of my colleagues to the school to meet the principal. She has clarified that there is no one teaching under this scheme or in the computer stream right now.
Mr. Jeezer Ahmed, and counsel for the petitioner. Mr. R. Mazumdar Leonard, standing counsel for the secondary education department, has submitted that the appointment to the contractual post of computer technician / instructor, for which this writ petition has been filed, is no longer a live issue, because as per instructions received by him from the secondary education department, at present, there is no scheme for appointment of computer technician / instructor on contractual basis. It is submitted that he has also received instructions from the principal. Mr. Mazumdar, principal or headmaster?
Principal.
Principal of TC Government Higher Secondary School, that at present no one is working in as computer technician / instructor in the school. Next paragraph. You have the said submissions from the learned counsel for the petitioner. Principal is granted time to obtain updated instructions as to whether the subject matter of this repetition is alive or not. List on 8 May 2023.